everybody. Oh my God, it's been a minute since we've streamed. How y'all doing? Good morning. It has been a while since we've had a wonderful trial stream. Let me know if you could see and hear me by putting a 1 in the chat, and we have a lot to catch up on. We have the remaining YSL co-defendants in court today. We're going to see if they accept some plea deals. In another courtroom, we have Judge McBurney, who is going to be looking at Yak Gotti's situation, and he can possibly come home today. So we have that as well. We have both feeds up. As far as Shannon, his proceeding is not going to be streamed. So a lot to catch up on. We're going to jump right on in. It's so good to see y'all. I feel like we haven't done this in so long, but don't worry, there is plenty to stream. Look at our friend, Miss Judge Whitaker. Let's go. And it looks like the courtroom volume is extremely low.
And you're not supposed to file it in the case, and you're not supposed to send it to chambers. You're supposed to send it to our public information office, and then they take it from there. But I mean, I am aware of it, so just in the future, if you can try to do it the correct way.
Of course, I think my colleague filed that one, but
okay, well, yeah, you can blame it on your colleague. That's fine. But anyway, in terms of, I do not mind if you have. And I don't even know if notice went to anybody or if anybody is going to have any objection. That's one of the reasons why it needs to be done a particular way. So I don't have to find out when we have everybody here, but assuming no objection, you certainly may use your laptop. And if y'all have a still photographer ever, that's welcome. Any other kind of like feed can just go through the pooled camera. All right. We'll just wait till we get everybody before we get started.
And while we do that, hit the like button for me, guys. It's been a while since we streamed. The algorithm's like, AV, where have you been? Hit the like button for me, y'all. Good to see y'all this morning. Waiting for everybody to come on into the courtroom. It looks like they were just handling some Rule 22 business. For those that don't know, this is the remaining defendants in the YSL case to see if the state has worked out some deals with them. We also have our eye on a courtroom next door in Judge McBurney's courtroom to see what the situation for Yak Gotti is going to be. As we get settled, I'll run a poll to see if you guys think that Yak Gotti is coming home, which would be fantastic news for the Weinstein team and, of course, for Yak Gotti himself. We're keeping an eye on all of that. But it is so good to see you guys. Esteban, I miss you guys too. It's so good to see everybody. Pam is in the building. Amisha is here. Amanda Ben is here. Free Yak is right. He should be coming home. I think so too. I think so too, Break It Dawn. I think he is going to be released today. Man, we haven't done this in so long, y'all. Are y'all having YSL withdrawals? Craziness. Let me bring us up to the present. And I am going to check out what's happening in Judge McBurney's courtroom. It looks like there are several defendants over there. So I'm just checking in so y'all can see what I'm doing. I'm checking in on this courtroom, and it looks like other matters are being held. So, you know, depending on last name, Yak Gotti's case is going to be brought up as well. So coming back here, we are just keeping an eye in the courtroom and going from there. Shout out to Mango Gelato. So many of y'all are in the building. Butterfly is in here. Good morning. I'm sarcastic. Good to see you. Merry Christmas, unidentified co-conspirator. Silent Owl Scribe. Do I have more photo shoots coming up? I did get a white suit, y'all. the suit guy made me a white one. So I'm really excited. That just came in. And of course, it has the AV logo in the middle of it. Going to be fantastic. Little bit of a somber morning, y'all. I don't know if y'all saw my post yesterday, but there was a loss in the LawTube community. I don't know if you guys are familiar with Legal Vices, but it came to our attention that he had passed away within the last 2 days. He is a LawTuber in Korea. Just like me, would rise or shine, like, rain or sun, whatever was happening outside. He was trial streaming. He did a lot of classic trials. He covered Y&W Melly's trial. He covered the Travis Rudolph trial. He did a lot of work on, I think he did Karen Reed. He did so many of these trials. So it's kind of sad to wake up to that news, losing an attorney. But the LawTube community is mourning that loss. If you are interested, we are having a memorial for him on his channel, and that's going to be on December 27th. Jeff is fantastic. So it looks like some of you guys are familiar with him. Movement in the courtroom, a little bit of movement, not some head action, but we're seeing some movement. So that is fantastic. Well, we got some time. Let's knock out a few supers. Shout out to TSOJ. How are you doing, TSOJ? I think I was doing a few other projects and collabs with a few other people. I saw you in the chat. So it is good to see you over here. Welcome to the membership, the community. Shout out to a girl from Texas. Hey, sis. She says, good morning, gorgeous AV. Loving your hair, sis. Good morning, chat fam. I missed y'all so much. Y'all are really like family. Slat. That's right. We have our little Chatterhood family over here. And a girl from Texas gifted a membership. Scooby, it's good to see you. Oh my gosh, this is like a little reunion, y'all. Like this is like a little Chatterhood reunion. We are just waiting for them to come back in the courtroom. We haven't done this in a while, so I'm gonna do a poll. Do you guys think that Yak and Shannon are coming home? I hear that Kayla is doing a stream tomorrow on her side, so it is probably a welcome home stream. We will see. We will see. We back. We are back, folks. Lucretia has been a member for 5 months, says good morning, AV. Good morning, sis. Hope you're having a good morning so far. It's going to be a good day. And it looks like we will have, it's not going to be like a short little session. It looks like we'll have a few hours together, y'all. A little bit of head action on the bench. Judge Whitaker is up there. We're waiting for all the defendants to come through. Okay, some movement in the courtroom. This is great. This is great. This is so exciting. I really wonder if he's going to come home today. Let me set up that poll for y'all. How's y'all week been? How has y'all's week been? I know we have been busy. Somebody came through and said, I'm so sick of Fanny. Oh my God. Did y'all hear about that whistleblower thing? I'm still trying to listen to the audio to see if it's something I should even put in front of y'all. But there is this whistleblower that allegedly talked about how Bill Barr, listen, here's a tea. So allegedly, Bill Barr was behind this whole RICO scheme for the Trump case in Georgia. And apparently, Fani didn't even want to bring the charges against him. But I don't know. That would be crazy because Bill Barr worked with Trump for a long time, but it is alleged that they didn't get along or something like that. So, guys, that is tea. I'm just verifying it because, we got to make sure this stuff is legitimate. But build it as you fly it, right? Ooh, Nathan is about to turn on font. Is that what's happening? Oh, interesting. Bill Barr, I believe, was the former attorney general under the Trump administration. And then I think he got fired. So I don't know. The tea on that one is hot. Thank you guys for hitting the like button. And as you do, when you do that, because right now it's like people need to know I'm here. I haven't streamed in a long time. So, the YouTube algorithm is being a Karen this morning. It's just like,
sorry, you haven't been streaming in a long time, so I'm not going to push this out. If you want me to push it out, you got to get your people to hit that like button. Sorry.
Like that is a YouTube algorithm today. It's like, nope, nobody's playing with you. Like, you want me to tell people that you're live? No, you got to get your people to hit the like button. So thank you guys that have done it. Ace is like Queen Slab. Listen, all of our jokes from this case, it's like, man, a year and a half, like running this trial, and it's finally coming to an end. Hi, Keita. It's been forever. How you doing? You like my little Karen voice? The Karen voice. We are waiting for them to come to start in the courtroom. Judge Whitaker just popped in. We are all out of TiVo time, but what we're waiting for is all the defendants to file in. Shannon's session is not going to be streamed today, so we won't know what's happening until later. Of course, you guys know we got people on the ground. I was talking to Dennis Byron earlier today, so as soon as we know something, I will have word on what Shannon's situation is. So we have ears on the ground over there. Gotti is in a different courtroom. I am checking that out. It's in Judge McBurney's courtroom, just down the hall. And it's so funny because Doug Weinstein was here last week, and I believe he told us that that Whitaker was presiding, but I guess they had some changes last minute. Let me put this poll up for y'all because I am a little rusty. Start a poll. Are the boys coming home today? And by that, I mean SB and yeah. Yes or no? Hold up. We have a poll up. Let me know what y'all think. Mark the Paralegal, how you doing? I feel like I haven't seen y'all in forever. When you get used to streaming every single day, and then you're not. It's interesting. It is interesting. Who else do we have in the building? Shout out to It's Me, Ecstasy, who's been a member for 2 months, says, I'm still loving your channel. Happy holidays, all. I love it. Thank you so much for checking out the content. We still have plenty to go. Last week, we had the Ashley Merchant on, so we are chopping up that interview. She is just so smart, so brilliant. I mean, we all want her to run for office against you-know-who, but she would be fantastic in whatever capacity she gives back in. Great defense attorney. We had some time with her. We are working on a Georgia prisons a video as well. For those that didn't know, Shannon filed a class action lawsuit last week against Rice Street. And it's pretty interesting, like the details within there. I think it was about 60 pages. I did read it. I was tired as hell. Y'all are like, AV, are you lit? I'm like, no, it's 10 o'clock. I'm tired. So we have that. We're chopping up that footage too. If you are a member, actually, did I do it yesterday? I think it was the day before. I put up, we're trying to do the best moments of 2024 legal wise. It could be anything, whatever you thought was an interesting legal moment. We're compiling y'all's ideas on that as well. So for those tuning in, we're just waiting for the proceedings to start. We were supposed to start at 9:30, but of course we are not on time. So not a surprise there. Shout out to a girl from Texas who gifted another membership. Thank you so much, sis. All things are bigger in Texas, including a girl from Texas's heart. She's such a sweetheart. She is such a sweetheart. Thank you so much for growing our community, the little channel that could over here. We're growing. We're growing. Shout out to the Golden Lounge, who has been a member for 3 months. Golden, I haven't seen you in so long. She says, happy holidays to AV and chat. I hope everyone is safe and in great spirits. Same thing, same thing. You know, it's I was sharing the unfortunate news. We did lose somebody in the LawTube community earlier this week. You know, Legal Vices. And let me just briefly talk about him for a second as we wait. There are not many attorneys in this space that gave me a shot when I first started. Legal Vices was one of them. When I think I had like 5,000 subscribers, he would invite me onto his panel. And, you know, there's not a lot of law tubers of color. There's a few people. It's like Nate the lawyer, Natalie the lawyer chick, Kayla now, lead, myself. But back then it was really just, take Kayla out of it, it was really just like 4 or 5 of us. And so, you know, when Jeff would come through, he would like check out my content and actually leave comments. I'm like, wow, you actually watch me. And he's like, no, you're actually pretty funny. You're pretty cool. And what I loved about that is he saw my content outside of, you know, other spaces that I used to help out in. And he just invited me onto his panels all the time. Those were the F It Fridays. Those were fantastic. And we would just chop it up, talk about different cases, talk about some of the things that were happening in the legal industry. And I'm going to miss him. I really am. You know, we were actually supposed to collab. You know, we were just talking on Twitter like a few weeks ago. And that's why health is so important, y'all. You never know. And I really worry about YouTubers because, you know, he passed away from heart failure. And y'all know Kevin Samuels had some things similar. His was hypertension. So it's so important to get up and move. You know, these are long days. Like y'all know, we would be sitting in these chairs for 8 hours watching trials. But Jeff is amazing. He always just put so many people on. There was never any beef with him, nothing like that. I met so many people through Jeff. I think Jeff is how I found Cat Not Williams. Through Jeff is how I found so many other creators. And like now these people are friends. You know, me and Kat had a great conversation yesterday. I was just chopping it up on the phone. You know, like it's just great that you can meet different people through people. Even Chandler Remy, from Remy Legal. She's been on this channel so many times. And like me, Chandler and I were super cool because she was Jeff's co-host on Legal Vices. So I was like, hey, co-host life, you know, like made a new friend through Chandler. So, you know, Jeff is dearly going to be missed, but it is just so important, y'all, to keep your health up. And I'm gonna do it too. You know, we're gonna trial stream the Karen Reed case for the next few weeks on this side, just because I don't know. They're talking about moving her trial to April. I read that her trial possibly is moved to April, but the original date was January 27th. So maybe like once or twice a week, we can rewatch the trial. So that way we're all caught up for round 2. Her case ended in a mistrial. And it is juicy because allegedly there's a lot of corruption. I'm in Boston, so very, very close to the courthouse. Going to be doing some field work for y'all on certain days. I will be going to the courthouse when that case is live as well. So plenty to do in 2025. Lots of content, a lot of new cases heating up. Did y'all see the whole Jay-Z thing? Turns out that little girl was lying. I mean, I was like, oh my God. Well, she's not even little anymore. You know, allegedly there was this 13-year-old that went to a Diddy party and Jay-Z and Diddy did something to her while another celebrity who was a female was watching. We all had questions because we're like, you're 13. How are you at a Diddy party? And I think she was from, where is she from? Alabama? She was from Alabama. And it's like, how did you get all the way to New York or wherever the VMAs were at? You were waiting outside. The other fishy thing about the story is the limo driver pretty much was like, hey, do you want to get in this car and go to a Diddy party? And she was just like, yeah. And he's like, all right, let me go drop off these other celebrities. I'm going to come back and get you. And then I'm going to drop you off at Diddy's house. And that's what he did. And, you know, at the time, it's under the New York Survivors Act. So she's a Jane Doe. And the crazy thing about this is, and we did a video on it. None of you guys watched it. I don't know why. But we did a video on it and we looked at the responses throughout the week. Because it looks like, y'all remember Busby, who is the attorney in the case, right? He did a press conference in like October, big 1-800 number behind him. Hey, if you've been impacted by Diddy's, you know, shenanigans over the years, call this number now. 1-800, call me now. And like thousands of people called. It was like 2,000 people that actually called that 1-800 number. And then they boiled it down to the 130 cases. This was one of those 130 cases that was allegedly the best out of the bunch, right? So that happens. This lady's case is one of those. So they file it and they start negotiating with Jay-Z. They start negotiating with Jigga. And they're like, listen, Jigga, we don't know what's going on. you know, this woman is saying that these allegations are true, right? There's something called Rule 11 in the Federal Rules of Evidence, right? It's actually civil procedure, where attorneys have to sign and attest that everything that they put in that lawsuit is true, right? That's the big thing with Busby. So negotiations were happening, and Jay-Z was like, hell no, I didn't do this. You're trying to extort me. You want money, and you're not going to get it, right? So negotiations broke down. Last Sunday, December 8th, since the negotiations broke down, they revealed his name because the lawsuit was filed in October. Took Jay-Z's name, the sticker Celebrity A, ripped it off, and it revealed it. It was Jay-Z. Hit the internet by storm, was reported by ABC, NBC, Fox, all the media networks were reporting it. Once that hit, your girl was on here and I was reporting on it, read the lawsuit to you guys. We read it together and we looked at what the girl's allegations were. Okay. Jay-Z puts out a statement from Rock Nation and it was just like, none of it is true. I'm fighting this tooth and nail. You're not getting one red penny from me, Busby. Not one. Very confident and assertive in the response. Busby, last Wednesday, comes out and says, you know, Jay-Z's been attacking me. He's been attacking my family members, threats on my family members. They've been publicly feuding about this thing for a few weeks now. Then this interview comes out on Friday where the girl's dad just like, yeah, you know, I didn't drive her anywhere. Like some of the things in that lawsuit are not true. I'm like, oh my God. What? So the shenanigans just continue. They just continue. Let me check on this courtroom, guys, because that's where we are. Apparently she's lying. But yeah, we are just, I went long-winded story about the Jay-Z thing. I just wanted to give you guys an update on it since nobody watches my videos. You know, I'm like, what is going on? All right, we are live in the courtroom. Still waiting for them to come back. What's going on over here? I do see Atlanta News First streaming something, so I might pop on over to that stream in a second to see what's going on. Anywho, so we're just waiting for them to start and then we'll go from there. But thank you so much, Golden Lounge. It was good to see you. It is good to see you. Shout out to D with the 5, says Plea deals with the same people who run Rice Street. You should know better. Seriously. Shout out to the professor who is saying that the girl is not lying and I need to do more research. That's nice. She never said her dad drove her. Okay, thanks, professor. Shout out to Miss Crow T. Shetty with the $10. No comment, no question, pure love of the game. Thank you so much. Okay. Shannon hearing is on with Nick. I'm looking at it. Law and Crime is a little bit late. So let me stop sharing and I'm going to start checking out a few other feeds, guys, because I just was talking to Thugger Daily, who told me that some of this is not going to be streamed, that Shannon's was not going to be streamed. But I see Mr. Abate in a different courtroom. And let me pull up Atlanta News First as well to see what they got going on, because it looked like there's some action there. I just saw Judge Whitaker over here. So build it as you fly, guys. All right. Oh. Atlanta News First has Shannon's thing. Let's screen share this while we wait for Law and Crime. Stream live. Okay, we got some action over here. Thank you again, Miss Crotty Shetty. Thank you, lovely May, for gifting a membership. Here comes drama, also gifted. Thank you, sis. Yeah, this just started about 17 minutes ago. And I do see Max Shard in the courtroom. There's Max.
So you need a few minutes, we can do something else.
Yes, Your
All
Honor.
right, that's fine.
Thank you.
All right, so looks like Max
We will
is
move
there.
To the all-purpose criminal calendar, position number 1, indictment 22 SC 182298, Denise Dillard. All right, we'll hold. Position number 2, indictment 22 SC 182298, Russell Green.
Judge, he's here. I'm not sure if they're still gatekeeping.
All right. Position number 3, indictment 22 SC 185220, Terry Relaford.
Good morning, Your Honor. Cameron Mackey on behalf of Mr. Relaford. He's present with us by way of Zoom.
And who's the ADA?
Judge Frank Marquez on behalf of the state. I'm filling in for Miss Washington today.
All right, Mr. Mackey, we're here for case management. So where are we on this matter?
That's correct, Your Honor. We have received discovery. I've not yet received an offer, but I understand Ms. Washington is currently in trial, so we're going to circle back when she gets out of there. But this case is ready to be put forward to a final plea calendar.
All right, we'll move it on to a final plea calendar. You will be notified of the next court date. And if there's nothing further, all parties are excused.
Thank you, Judge.
Thank you, Judge.
Position number 4, indictment 23 XC 191773, Jeremy Malone.
Good morning, Your Honor. Cameron Mackey on behalf of Mr. Malone. He's present with us, but he's in custody.
Position number 5 is also Mr. Malone, indictment 24 SC 003090. Mr. Marquez, are you representing the state on both these matters?
I am, Your Honor.
All right, they're both on for case management. All right, good morning, Mr. Malone. We're here today for case management. Mr. Mackey, where are we on position 4? And then we can move to position 5.
On position 4, we have received discovery and an offer. That case is ready to go to a final plea calendar. And Your Honor, I believe that these are already scheduled for final plea in January.
Yes.
So we're expecting to do that on position number 4.
All right, position number 5 is indictment 24 SC 003090.
And Your Honor, for that case, we have received discovery this morning. There was an issue with an interview that wasn't playing nicely with the evidence.com. So the state has kindly provided me with a USB that contains that file this morning. This case is also on for final plea for January. I am going to review the interview, and if I have any additional motions, I'll file them by the end of the week.
All right, thank you. Anything from the state?
No, Your Honor. And we did extend an offer on both cases, Judge, just for the court's information.
All right, so we will look to see you all in January for final plea. If there's nothing further, all parties are excused.
Thank you, Judge.
Thank you, Judge.
Position number 6, indictment 24 SC 004656. Kevin Mercado.
Judge Theros Mercado, he only speaks Spanish. I requested a Spanish interpreter. I sent Mr. McKeon an email about that. I don't see one yet.
All right, well, have a seat. We'll come back to you.
And also, Judge, position 2, Russell Green, they've let people now in the courtroom. So he's present if you wanted to return to that one.
Position number 2.
Yes, Judge.
All right, position number 2, indictment 22 SC 182298. Russell Green. Mr. Marquez, are you representing the state?
I am, Your Honor. Just so the court is aware, the state is going to be submitting a null-cross on positions 1 and 2. I thought we had already done that, but clearly not.
And real quick, some of you guys are asking what's going on. I have all 3 courtrooms up. So the thing about today that is different, it's a little difficult for a streamer, just to be honest. I have all 3 courtrooms up. First courtroom is Law and Crimes Feed. That is going to cover the remaining 5 defendants. Those names are Christian Eppinger. That's Briss. That's the guy that shot the police officer. You have Myles Farley. You have Demekion Garlington. Demise McMullen, aka Demise, right? Tencarius Mender. They're all expected in court today. Judge Whitaker popped in briefly. They're waiting to get organized in that courtroom, so I have that courtroom up. Now, Shannon's proceedings, I did not think was going to be live streamed, but that's what we have on the screen right now. This is being streamed by Atlanta News First. We just saw Max Shard walk by, so we know he is in that courtroom. The judge asked him if he was ready. He said he needed a few minutes, so she is going through other matters before we get to Shannon. Now, on the flip side, I also have Yak Gotti in a different courtroom up as well. I do see in this, they're going through other people's cases. So it's not exclusively YSL and these other 2 courtrooms, but in the Law and Crime Feed, it is simply YSL. Okay, so that's what's going on. I have the Shannon one up because Atlanta News First called it the Shannon feed. So that's what we're watching at this time. But I'm just checking in on the other courtrooms and we'll keep you guys updated as we go. But let's go back to this one because we might have a Max sighting. But I will bring it to present time so that way we don't have to skip through all of these people. But let's bring it to present. And the judge she ain't even sitting there right now. So it is a little bit of a difficult morning just to get everything together. But that's what's going on. Looks like this. Whoop. Here we go. Now it's YSL.
The attorney yet for Mr. McMullen, but we have the counsel for everybody else. So we'll just go ahead and get started with the final pleas for.
Here we go,
those people.
guys.
Are there any guilty pleas that are going to be tendered today by any of the attorney, any of the defendants?
Yes, Your Honor.
All right, why don't y'all come on up to the podium, please? All right, Mr.
First
Farley,
up,
whenever
Myles
you're ready.
Farley.
And everybody, I'm just gonna give a reminder to just use the mics that are in front of you, and they're mobile, so you can move them up close so that everybody can hear.
This is indictment number 22 SC 183572, State of Georgia versus Mr. Myles Farley. Farley, please raise your right hand. You solemnly swear and affirm that testimony about to give the matters pending before this court will be the truth, the whole truth, nothing but the truth, sir? Yes, sir. Hey, put your hand down. Could you please state your true, correct, and legal name for the record? I'll let you sign before I ask you more questions. Two things at once.
And Mr. Gotti, maybe reposition the mic while he's doing that.
Yes, Judge. Mr. Farley, could you state your true, correct, and legal name for the record? Farley. And Mr. Farley, are you at this time taking under the influence of any alcohol, drugs, or medicine? No. Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here? No. And how old are you, sir? How far have you gone in school? I got a bachelor's. And are you able to?
Also speak into the mic, please.
26 and got a bachelor's degree. And so are you able to read, write, and understand the English language? Yes. And do you understand you are charged in indictment number 22 SC 183-572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is a possession of a firearm and the commission of felony. You understand you're currently charged or indicted with those counts? Yes. And do you understand that you have the right to plead either not guilty, guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial. Yes. And has your attorney, Mr. Menendez, gone over the rights that you're waiving by taking a guilty plea here today, sir? Yes. And are you satisfied with the services that your attorney has provided? Yes. And do you need any additional time to talk to your counsel about any of the facts, circumstances regarding the charges and the circumstances of this case? No. And Mr. Menendez, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing or plea?
Yes, so waived.
And Mr. Farley, has your attorney spoken to you about the minimum and maximum penalty for the counts that you're pleading guilty to? Yes. And he advised that for count 1, RICO, the minimum is 5 years, the maximum is 20 years? Yes. And do you have any questions as it relates to that count, the single count you'll be pleading guilty to? No.
Okay, so real quick, guys, I'm hearing an update that Kayla is in the courtroom next door. So I'm trying to look into that as well. But it looks like she might actually be in the courtroom. So I'm trying to bring that up. And Gotti, she's at the table with Gotti. So we're going to switch real quick. Let's see what's going on over here. Unmuting this. I'm going to unmute
and what that bond should look like. And then I'll hear from Mr. Rao, and then you'll hear from me when you're ready.
All right, Ms. Bumpus is taking the podium.
Good morning, Your Honor.
Good morning.
And if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. As this honorable court, I'm pretty sure it knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And as we know, that is one of the factors in this court considering the bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity, given a bond. This is a jail incident, Your Honor, and I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're gonna get a jail case. it's almost inevitable. And especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to be given a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom or?
No, he was in trial, but the co-defendants were.
Okay, so there was a prelim, not as to him personally and directly because he was in 1C.
Yes, Judge.
But in 2B, one floor up, they went forward with some or most of the other defendants.
Yes, Judge.
Okay.
And in that case, it's my understanding that the judge decided that there was the facts did not arise to an aggravated assault, but a battery. And I know that, you know, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, you know, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are gonna work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions granted, given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom,
20K.
what that setting would be.
Let's get him out.
And what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years. So it's not like there's a job at this firm where he was working, hey, we held your spot for 2.5 years. But I trust you and he have discussed something about the structure that would be in place. And that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these 2 cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot, it's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street, and they'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety, you're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place, and the next day there's a dead guy in the parking lot. And it has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're gonna be working on getting a studio in wherever he resides, so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of it. Maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties. But could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end. It's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. And I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation, and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you, having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who've also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant, Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case.
Okay.
Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire.
Okay, guys, so just a quick update on what we're watching right here. We are trying to see if Yak Gotti can come home. These are separate charges. So I think it was Keyshawn that mentioned that. These are charges that he picked up while he was in jail, okay? So there were additional charges, even though he got found not guilty on the YSL matter. The big thing that's stopping him from coming home is this, right? So there were several incidents where Yak Gotti had been in fights in jail, and we're learning about one of them right now. And this person from the state, a different ADA, I don't know his name yet, he's arguing that he should not be released on bond. Today, Yak Gotti is being represented by Kayla Bumpus, so she is sitting next to him in the courtroom, and she has asked for a bond of $20,000. And the conditions, the judge was very concerned about Yak Gotti not going back to hanging out with the same people, not being at dangerous recording studios. They said one of the conditions is that they would put a studio in the house so that way he doesn't have to go anywhere. He just wants to focus on making his music, and he wants to be released. Kayla did also mention the December 1st issue that they had in the jail. You guys remember when Yak Gotti was on his final days of trial, he was stabbed in the head and he had to get staples to seal the wound. So we did see that. We'll see how this argument shakes out. I'm also keeping my eye on the law and crime feed as well as Shannon's courtroom as well. So we will kind of toggle between those, but we want to see what's going to happen with Yak. I could tell you from the YSL courtroom, one person has already pled out. So we'll catch up on that. I just find that this one is a little bit more prevalent. So let's keep going.
Entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your
Andrew.
Honor.
All right. Somehow that device's volume got turned down, but we're back. All right. So your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'm going to call it the assault case.
That's correct. And in addition to that, the sheriff's office had an opportunity to speak with Mr. Kendrick. And essentially there's a lot of commotion in the background because it's on a body camera footage. They were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both, but
Okay.
with respect to Mr. Kendrick, it's essentially he's saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and then the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor, 15 SC 140116. And it does appear that he is on active probation for that particular case, having been sentenced to a 15 years to serve 2 sentences with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assaults. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, Ms. Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the 2 cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations, or it would be something in aggravation, a bond hearing or a sentencing hearing.
That's
is
correct.
your best forecast, with maybe one exception.
That's correct.
Okay, all right.
Thank you, Judge.
Thank you.
Kayla,
Ms. Bumpus, want to give you the last
Please,
word.
Come on,
I'm
Kayla.
going to not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that, because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not two separate crimes.
Got it.
This 2015 is the federal case.
All right. So there just was dual sovereigns, and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not two separate acts. And in me saying that, I don't know if this brings any or can help us get clarity on the warrant, because my client's understanding is that the federal probation then trumped the state probation, and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimber. And you know that's how it flows. And so if that warrant is out there, then we need to work through that, and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed, or if it's lifted or it's dismissed, or I don't know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, and this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure. Good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured. So I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these two cases.
And Your Honor, how am I gonna, can someone email me about the probation or?
I will keep everyone in the loop.
Okay, thank you,
Okay.
Judge.
All right, Mr. Rao, anything else from the state? All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. You'll get it back when you leave.
All right, guys. So that concludes.
Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you for being here.
Okay, so that concludes the matter involving Gotti. All right. So it looks like he is not coming home today. We are going to check in on Shannon real quick, and then we'll go back to the main defendants that is also happening. So we're monitoring 3 courtrooms right now. We're probably going to go down to 2. So here's what we just saw. Gotti, unfortunately, is not being released right away. Kayla Bumpus came in and requested $20,000 for bond for 2 situations. The state does not want him out. They requested that the bond be denied. The reason why is because there were a series of jail fights and things where he picked up additional charges. However, it is kind of a conundrum because Kayla did clarify, like, he was never charged with those offenses. Those happened in jail. Now, the prior things that he's already served time for is something else that we need to talk about. Then the judge does a search and finds out that there's an outstanding warrant and some probation as well. So what they're doing, they're not letting him out immediately. The judge did not make a decision because he wants to look into the probation matter and also wants to look into the warrant matter. If that can be resolved, then it is likely that Gotti will be released, but the judge is doing the right thing. He wants to be fair. He wants to make sure that Gotti is safe when he gets home. There is a risk of reoffense and things of the like. So that's Gotti's situation. I think this judge was very, very fair, pretty fair. So, that's a good thing. I am going to stop sharing, bring us to the Shannon courtroom and see what's going on. It has come out, guys, that Kayla is married to Shannon Stillwell. Max is defending him. I am a little confused, though. Like many of you, I thought Doug was going to be supporting Gotti through this and representing him, or at least Doug's office. Kayla's there, so it seems like, she's pretty close with these gentlemen. What just happened? Sorry, guys. I lost the window. I'm like, what just happened? Am I still live? No, I'm still live. The screen froze for a second there. Sorry about that, y'all. We have some slow connection today. I'm just bringing up the other courtroom and we'll go from there. But what do y'all think? I mean, I thought he was going to be able to come out right away, but it seems like that is not the case. So let us check in on the Shannon courtroom. It looks like no one is in there right now. I heard that Max Shard came up. I do see him at the podium. Let me screen share for y'all now.
Calendar with indictment number 1, 22 SC 181814, Shannon Jackson. His attorney is present. And the state is represented as well. We also have indictment 22 SC 185532 and indictment 23 SC 188183.
Your Honor, before we get started, may I approach with something off the record?
State has to approach as well.
Okay, so we're about to see what's going on. This is the matter of Shannon. So we got Yak's situation tabled for the day. And they are going behind the door there. It looks like they are still back there. Okay, we are now live. So it looks like they're on a bench conference right now. the judge, Max Shard, and the state are they are having a discussion, a sidebar discussion. You can see Kayla at the defense table right now, so she is likely sitting next to Shannon. I don't know. I haven't seen Shannon in the courtroom yet, but there is Kayla. So she has switched from one courtroom to the next one. We are waiting to hear what happens with Shannon Stillwell live. Interesting. Thank you, CEO Michelle, who says Doug said he had other cases. He posted a TikTok addressing that. Thank you so much, CEO Michelle, for the update. It looks like she is co-counsel and supporting Max. Interesting. Interesting turn of events, y'all. I didn't expect this day to go like this. But yeah, we are watching Atlanta News First. This is live. We still have the Whitaker courtroom up, and I will keep you guys updated on that. But hopefully Shannon's situation is a little bit better. Where are you guys at on the poll if you haven't voted? Are the boys coming home today? 75% of you guys said yes. Well, one of them is not coming home today. And you guys see the state's coming out swinging with all these charges. You know, the jail incarceration, right? Like if you need to defend yourself, you're going to bring additional, like call the person a danger to society. When, you know, if you got to fight back and defend yourself, you got to do it, you know? Hopefully Shannon has better luck. All right, here they come. Y'all ready? Put free if you think he's going to be let out. Put not free if you think he's going back to jail. Let me know what y'all think, chat. Fingers crossed.
We're back on the record. Bring the defendant, Mr. Jackson, out, please.
Here he comes, y'all. Chat's pretty mixed right now. You guys are pretty half and half. Yeah, this judge's energy is a little different from the last guy, so I don't know. All right, here comes Shannon, guys. Here he is.
Good morning, Mr. Jackson.
Good morning.
As you stand before me today, you are here on 3 indictments. Indictment 22 SC 181814, indictment 22 SC 185532, indictment 23 SC 188183. My understanding in consultation with the state and your attorney is that we have a global resolution to all 3 cases. Is that correct?
That is correct, Your Honor.
All right, and you're going to be entering a plea of guilty to certain charges in these 3 indictments. So if you will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I need for you to tell me your name and spell it, please.
Shannon Jackson, SHANNON,
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand today's proceedings?
No, sir.
And how old are you?
32.
What's the farthest level of education that you've gone?
9.
Can you read, write, understand the English language?
Yes, sir.
And you're a little soft-spoken. Do you mind speaking up a little bit for Madam Court Reporter? All right. Now, do you understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm during commission of a felony, possession of a firearm by a convicted felon?
Yes, sir.
You understand the maximum possible punishment on the possession of a Schedule 5 is up to 3 years in confinement.
Yes, sir.
You understand the maximum possible punishment on possession of a firearm during commission of a felony is up to 5 years, which would have to run consecutive.
Yes, sir.
You understand the maximum possible punishment on possession of a firearm by a convicted felon is up to 10 years in confinement.
Yes, sir.
Now, you're also charged in resolving today case number 22 SC 185532, in which you were charged in count 1 with serious injury by vehicle, count 2 entering auto with intent to commit a felony, count 3 theft by taking, count 4 failure to maintain insurance. Do you understand that as to count 1, the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
Do you understand that for the entering auto, the maximum possible punishment for which you could be sentenced is up to 5 years in confinement?
Yes, sir.
And do you understand that for the theft by taking, based upon what the amount alleged in the indictment, that being greater than $5,000, less than $25,000, the maximum possible punishment for that offense could be up to 10 years in confinement?
Yes, sir.
And do you understand that count 4, the failure to maintain insurance, is a misdemeanor punishable by up to 12 months in confinement?
Yes, sir.
Now, as to case number 23 SC 188183, you were charged in counts 1 and 2 with participation in criminal street gang activity, count 3, possession of methamphetamine with intent to distribute, and counts 4 through 8 with possession of prohibited items by an inmate. Do you understand that for those counts 1 and 2, the gang activity, you could be sentenced up to 20 years in confinement?
Yes, sir.
Do you understand for the possession of methamphetamine with intent to distribute, you could be sentenced up to 30 years in confinement?
Yes, sir.
And do you understand the maximum possible punishment for each of those possession of prohibited items by an inmate is up to 5 years in confinement?
Yes, sir.
Now, do you understand that you have the right to plead either guilty?
Sorry for the brief interruption, guys. Just from a legal standpoint, I know that we can critique others, in my opinion, and we walked through what the arguments were. Kayla did respond to what the prosecution had, actually challenged one of the things that the prosecutor did say, and the judge agreed with her that he was not charged for some of those crimes. She actually did fairly well, right? So that's just from my perspective. You know, everybody's entitled to their opinion, but I see some chatter in the chat, and I just wanted to address that pretty quickly. But I will say, as far as lawyering, she did what she could. That warrant is something that the judge absolutely needs to look at, because he did a search and it came up. So if anything, you know, maybe she could have mentioned that. That's my only critique. But if the judge has to do a search, he's going to do it for every defendant regardless, right? So there's that. But let's keep going to see what happens with Shannon. It appears that he is accepting a plea deal. And right now, the prosecutor for the state is going through the terms of what he is pleading guilty to. All right, so let's go back in, and then we will go back to the other courtroom and see what's happening with the other YSL defendants. But these are the main two. Gotti is not coming home today. Doug Weinstein had other matters to take care of. Kayla stood in for him. And right now we have Max Shard with Shannon Stillwell right now. Kayla is in the courtroom. So let's see how this shakes out.
Or not guilty to any and all of these offenses. And if you pled not guilty, you would have the right to a jury trial in which the state would have to prove your guilt beyond a reasonable doubt.
Yes, sir.
Now, as your attorney, going over with you this form that I'm holding, the plea of guilty acknowledgement waiver of rights.
Yes, sir. Armand.
And did you have an opportunity to review this form, go over this form in its entirety, and do you understand this form?
Yes, sir.
Now, Mr. Shard, are you waiving any potential defects in this indictment on behalf of your client, as well as formal reading of the indictment?
So waived to both.
And Mr. Jackson, do you need any more time with Mr. Shard? Are you prepared to move forward at this time?
No, sir.
Now, in relation to this particular case, I believe you've been arrested on all of these offenses. Do you understand that if you enter this plea, that this also can be used in the future? It's what we call recidivist punishment, which means that if you got in trouble down the road, a court could look and see these convictions and therefore go ahead and sentence you to something greater than it normally would. Do you understand that?
Yes, sir.
You also understand there could be what we call collateral consequences to this plea. What I mean by that is that this can have a negative impact on, say, your ability to vote, your ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And do you understand this is a negotiated plea of guilty?
Yes,
Which means that your attorney and I in the state have come to a global resolution. We're going to go ahead and propose that to the court and the court can choose to accept or reject that. However,
Ooh.
if the court chooses to reject it, it could sentence you to something greater than what is negotiated. Do you understand that?
Yes, sir.
Now, do you also understand that if you are under probation or parole, that this can have a negative impact on your probation or parole status? And to be clear, this would not have a negative impact on the offense for which you just were sentenced, as all these offenses occurred prior to entering this plea. Do you understand that?
Yes, sir.
Now, do you also understand that because this sentence will also include provisions of probation, that you will have to comply with all of those terms of probation, which also would include not possessing a firearm?
Yes, sir.
You also understand that possession of a firearm, aside from a probation violation, also would act as a new offense as you are convicted felon.
Yes, sir.
Now, do you also understand that there can be, let me get there. Do you understand that you're waiving any and all defenses, including any mental health defenses, by entering into this plea of guilty?
Yes, sir.
Now, do you understand? I'm going to read off a list of rights here. At the end, I'm going to ask if you understand you're waiving all of those rights, okay?
All right.
Do you understand that by entering this plea, you're waiving the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I understand.
Now, has anyone forced you, threatened you, or promised you anything to get you into entering into this guilty plea?
No, sir.
Now, your attorney has worked out certain cases in which, and certain counts in which you're entering a plea of no contest, as well as Alford v. North Carolina, okay?
Yes, sir.
So I'm going to go over each of these indictments specifically as to the counts. Do you understand Alford v. North Carolina is a situation in which you're not admitting that you are in fact guilty? However, you do recognize that it's possible a jury could convict you, and therefore you believe this is in your best interest to go ahead and enter into that plea. Do you understand that?
I understand.
All right, so we're going to begin with case number 23 SC 188183.
Here we go.
You understand you're entering a plea of no contest as to the participation in criminal street gang counts, which is 1 and 2.
Yes, sir.
You understand that you'd also be entering a plea under Alford v. North Carolina in counts 3 through 8, which is the possession of methamphetamine with intent to distribute and the possession of prohibited items by.
Yes, sir.
Now, do you understand as to case number 22 SC 181814, your attorney has requested, and the state is not objecting, to an Alford plea as to the count 2, possession of a firearm during commission of a felony, and count 3, possession of a firearm by a convicted felon.
Yes, sir.
And then that your plea would be a plea of guilty as to counts 1, 2, 3, and 4 on the 22 SC 185532, that being serious injury by vehicle, entering auto with intent to commit theft. I apologize, you know me, I'm annoying. By taking failure to maintain insurance.
Yes, sir.
Now, Mr. Sharp, understanding that you negotiated these with other attorneys and sort of standing in place, that I fairly accurately summarized the counts for which are the no contest as well as the offer.
Yes, sir.
All right, understanding all of that, how do you wish to enter your plea?
Guilty.
All right, and that be guilty as to on the 22 SC, the serious injury by vehicle, the entering auto with intent to commit felony, theft by taking and failure to maintain insurance, is that guilty?
Yes.
As to the 22 SC 181814, which is the possession of a controlled substance, the possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon, as to counts 2 and 3. Is that under Alford v. North Carolina?
Yes.
And then count 1, the possession of a Schedule 5 controlled substance, is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2, the participation in criminal street gang, what is your verdict, or what is your plea?
No contest.
And the counts 3, possession of methamphetamine with intent to distribute, and then the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the Alpha.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you would have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date is to file what we call a habeas corpus, and that's if you wanted to challenge the constitutionality of this plea.
Yes, sir.
And do you understand that there is one misdemeanor on here, which is the failure to maintain insurance? Do you understand that you would have up to 12 months from today's date to also file that habeas?
Yes, sir.
Your Honor, I'm going to go ahead over what the factual basis is at this time for each plea, if it pleases the court. Judge, I will begin with the serious injury by vehicle case, which is the 22 SC 185532. Had this case proceeded to trial, the evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission, that vehicle being greater than $5,000 but less than $20,000 in value. Judge, the defendant also did not have valid insurance at the time of the motor vehicle collision nor the departure from the scene. Judge, as to case number 22 SC 181814, had the case proceeded to trial, the state would show that on October 27th of 2020, law enforcement with Atlanta Police Department responded to an address on Judy Lane, which is located inside of Fulton County. They responded to that location because the defendant was parked inside of a driveway where he did not reside. Upon approach, law enforcement observed what appeared to be a prescription bottle. Judge, a canine came around and positively tested, positively alerted as to contraband inside of the vehicle. The defendant was a convicted felon at the time. Law enforcement was able to locate a loaded firearm inside of that vehicle, Judge, in addition to locating promethazine, which was the Schedule 5 controlled substance. And Judge, finally, as to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. Judge, that was a shared cell, and located inside of that cell included a cell phone, the pills that tested positive for methamphetamine. Judge, the quantity would be consistent with the intent to distribute, as well as a shank, which is often used in either self-defense or to be the initial aggressor or primary aggressor, depending upon what day it is at Rice Street. And Judge, possession of Apple AirPods and an iPhone as well. Judge, I'll begin with what the negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served. Judge, as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served. As to count 2, that would have to run consecutive to count 3. So count 3 would be 10 years probation, and count 2 would be 5 years probation to run consecutive, for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10, the count 2 was going to be 10 to serve 3 commuted to time served, balance on probation,
Yes.
as opposed to 10 years probation.
I will defer to you as you were the one actively involved in the negotiations.
Let's see, Judge.
Mr. Sharp.
But it's looking
Okay, so
good.
if you just go over those again for the record, for count, for 22 SC 181814. Count 1,
Is possession of controlled substance, that would be 3 years commuted to time served. Count 2 would be 10 to do 3 commuted to.
You can't do that if you're going to do count 3, because count 2, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count 3, the possession of a firearm at some period of time, so statute minimum of 1.
Okay.
So if we're going to get there, man,
I don't have the indictment in front of me. I think what I meant to say is count 3. Count 3 would be 10 to do 3 commuted to time served. balance probated, and count 2 would be 5 years probation consecutive.
Correct.
The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The
Oh,
intent
that's an
is
important
it would be
distinction.
12 years probation because he's already served those 3 years.
All right, so let's be clear. Count 3, 10 to serve 3, commuted to time served, balance on probation. Count 2, 5 years probation, consecutive to count 3.
Yes, Your Honor.
Yes, Your Honor.
And count 1, 3 years to serve, commuted to time served.
Correct, Your Honor.
Yes, Your Honor.
You may continue.
And as to case number 23 SC 188-183, as to counts 1 through 8, they all would be a concurrent 5 years to serve 2 years, the 2 years commuted upon time served. Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of this sentence. He is to maintain gainful employment while on probation. There would be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There is to be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street gang. And there is to be no possession of a firearm on his person in any vehicle in which he occupies nor any residence. Quite frankly, just no possession of a firearm, given he would be a convicted felon. Judge, I also understand, and Mr. Sharp had approached me about concerns about being able to travel through the Atlanta airport. There would be no objection to an exception for the Atlanta airport. Judge, this is the only case that was assigned to my unit, and I believe it actually was initially with the high profile unit, was the gang case. And so, Judge, I do want to clarify for future cases why I am consenting to a no contest on counts 1 and 2, as it's not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship I've had with Mr. Sharp over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Judge, understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, who's had some incidents, unfortunately, at the jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present, specifically because he is already a C recidivist. This is irrelevant, frankly, whether or not we will be able to have three convictions in the future. Judge, understanding as well that the negotiated terms of the larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis as to this particular case, Judge, we are running into a situation, had this proceeded to trial, that this was in fact a shared cell. Judge, it's been in the past occasions where other individuals' contraband can in fact be found in other individual cells, or as well as the fact that there was.
I don't think they should bring in the jail stuff.
Individuals that would have had access. And Judge, in this particular case, I have not been made aware of any cellular dump in this particular case. Had a cellular dump been done in this case, and I've been provided with that, that would have demonstrated possession or control or intent over the narcotics or objects inside of that cell, we probably would be in a different situation. But I am not going to hold Mr. Jackson at Rice Street or ask him to be held at Rice Street while we did a cellular dump in order to ascertain that if we have a resolution that appears to be amicable to all parties. So just for future no contest cases, I want to be able to distinguish Mr. Jackson from other defendants that maybe argued were similarly situated.
All right, thank you. So will you go over the special conditions again so I can make sure I have them correct?
Yes, Your Honor. The special conditions would include banishment from the Metro Atlanta area with exceptions for the Atlanta airport. Judge, that would also include that he has to maintain gainful employment while on probation. There is to be no contact or communication directly or indirectly with any named co-defendant in the 22 SC 183572 indictment. There is to be no contact or communication, either directly or indirectly, with any persons associated with a criminal street gang, as well as a no possession of a firearm. I do understand it may take a little while for him to be able to sort out the interstate compact, Judge. So there's going to be a sort of a grace period, at least from the state, in relation to him being in Fulton County until he's able to go ahead and work that particulars out with probation for the interstate compact.
Because another jurisdiction has to accept him as a probationer. correct?
Oh,
All right.
that's important.
Anything else?
That's going to Texas.
All right, anything from defense?
Your Honor, I would just like you to know that Mr. Jackson is 32 years of age. His father is present here in court. His father works an honest job for an honest living. His wife is also present in court, supporting him. He has 4 children. And so a lot of these past acts involve selfishness, immaturity. And I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is, and we only get one. And I think he wants to make everyone proud, all the supporters proud, and people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is. Yeah.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he would be allowed to return during the period he's banished? Did the state negotiate?
Judge, again, that was a negotiated term outside of the one. However, I understand that there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer to this court.
Your Honor, I anticipate that at some point in the future, there'll be a need to return back to Atlanta. I'm not trying to violate any agreements that I have with the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that that would probably be the best workaround at this time. And quite frankly, in the future, if things are going well on probation, then maybe we can revisit some of these conditions.
All right. Yes, but you have to tell us who you are for the record.
I'm Ms. Jones, Officer Jones with probation DCS. Due to the fact that where he's going, if they do not accept his case, we will have to come back in front of the judge to modify the seat. I don't know that right now, and I won't know that until 7 days from today. I have spoken with my AC, so I am trying to get the situation expedited, but he won't go to probation until Thursday.
All right, thank you.
Okay, that was a probation officer.
So essentially what she's saying is until the state that you are moving to accepts your probation, you will be here in Atlanta, and everybody knows that, somewhere in the metropolitan Atlanta area. Okay. All right, as to indictment 23 SC 188183, indictment 22 SC 181814, indictment 22 SC 185532. The court is going to find that the defendant has entered a pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alfred plea, or just a regular guilty plea. All right, so we're going to start with (22 SC 185532). The negotiated and recommended sentence is on count 1. The defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time served. Indictment 23 SC 188183. On all 8 counts, 5 years to serve, 2 commuted to time served, balance on probation to run concurrent with 22 SC 185532, count 1. And also in 22 SC 181814, the sentences are to run concurrent to count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay. So the people who used to be your friends or the ones they say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever. They're no longer people that you can have any contact with, because if you have contact with them, you run the risk of being violated on your probation and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. I understand that you were assaulted while you were at the Fulton County Jail. And unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it, because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems, because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, The next time you get a felony conviction, you're gonna be looking at a lot of years. And nobody's gonna say yes to probation under any circumstances. So the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so and notice has been given to the state and they've signed off on it. You are to not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any street gang, criminal street gang activity. I assume that you know all of the co-defendants in 22 SC 183572. So you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there. So there's no misunderstanding, okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing, if we could put on the sentencing sheet, that all these sentences are to run concurrent with the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532.
Well, it looks like that just crashed. Sorry about that, y'all. I'm bringing it back up. All right, hang on. The screen crashed. Give me 1 second.
In a timely manner and not cause
Concurrent with the sentence that
Sorry about that, y'all.
Mr. Jackson has from 22 SC 183572.
any objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
I'm sorry. Unless you want me to tell you or the court where I'm going to tell Mr. Jackson, I can talk to him.
Yes, just put it all on the record about reporting.
Okay, so he will report on December 19th to 276 Memorial Drive, Atlanta, Georgia, 30303 at 8 a.m.
So don't be late, don't miss that appointment because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right, so at this time, is there anything else from either party?
Judge, just Mr. Sharp had recommended, I have no intention of leaving my office anytime soon, at least voluntarily. So Mr. Sharp and I have built up a point of trust and communication over the years. I have no problem with Mr. Sharp reaching out to me if there's any exceptions that are necessary.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you.
All right, if there's nothing further, then all parties are excused.
Thank you, Your Honor.
There we go. Shannon Stillwell is going to be released, it looks like. So here's what we know. The judge gave him a lot of credit for time served. Huge shout out to Max Shard. This is a big win for him. That is great lawyering. You could see Max is
On the final
excited.
plea calendar,
He's
hold on.
happy.
Excuse me, position 1 on the final plea calendar.
He is likely going to
All right,
be released today.
position
Pled
number,
guilty to all of the things that they had mentioned. The judge was very fair. I think it was fantastic. If y'all could do me a favor, congratulate him in the chat. Congratulate Max Shard, one of the best criminal defense attorneys in the state of Georgia. I think he did phenomenal. And if you guys remember, Max Shard was here on this channel and told us, I think it was the exclusive, he told us that they had worked things out. So that means that Max had worked with the DA's office to work this out and make sure that it was a good deal for Shannon. So it sounds like a couple things that happened. I like this judge because one thing that she talked about was getting an education. You know, so many times judges will sentence you to things and not really care about your life after the fact. But another important job that they have to do is make sure that people are effective, members of society. And she's just like, it sounds like you stop your education after 9th grade, at least get your GED. Why? Because you need to get a job as part of the conditions to your probation, right? That also means that if you're going to have this probation, having a GED is likely going to show employers that you know how to complete tasks and things of the like. So she reinvested in Shannon, saying that is one of the conditions. He has to go and complete this work. Now, another thing that happened, he's not all the way out of the woods. He is likely going to get released, but they may have to come back in front of the judge because for his probation, it needs to transfer to the state of Texas. He's married to Miss Bumpus, so it is likely that they are going to have him in Texas, right? But what they have to do is check in with Texas to make sure that they are going to take over the probation, right? That's different jurisdictions, 2 different jurisdictions, 2 different states. It is likely that it's going to be fine, but in the event that it's not, they have to come back and renegotiate the terms. Now, let us go back to the remaining defendants in Judge Whitaker's courtroom. So we have a resolution for not really resolution for Yak Gotti. There's an outstanding warrant. Caleb Bumpus represented him today. Maybe we'll get some news on that this afternoon, but it does not look like he is coming out today. So Yak is returning to jail. Shannon did get a favorable result. We have one person that's right here, right now. I paused this earlier because I wanted us to go to Yak and Shannon's hearings. We're going to catch up on the law and crime feed and then go from there.
And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation to the court as to the sentencing recommended for the count that you're pleading guilty to, so the court does not have to follow that recommendation, and she can sentence you as she sees fit up to the maximum for the charge. Do you have any questions about that? No.
Is he just pleading to count 1 and y'all are null processing the rest as a part of the agreement?
That's correct, Your Honor.
Okay.
Now, do you understand? Mr. Farley, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts? Yes. And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else? Yes. Do you understand that you waive any and all defenses by entering a plea of guilty here today, sir? Yes. Do you also understand that by pleading guilty, you're giving up or waiving the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you.
I turned up the
right
sound,
to
y'all.
assistance of counsel hired by you or court appointed if you are unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges proved against you beyond reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. You understand by taking a guilty plea here today that you're waiving or giving up all of those rights? Yes. And Mr. Farley, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today? No. And are you pleading guilty, sir, because you have decided in speaking with your counsel, Mr. Menendez, that you believe that it is in your best interest to do so? Yes. And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alford, if the court accepts this plea of guilty, places you in the same position as if you were convicted after a jury trial? Yes. Okay. And how do you plead to count one, conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act in indictment number 22 SC 183572? Guilty on the Alfred. And Mr. Farley, is this
He just pled guilty to RICO.
plea freely and voluntarily given with full knowledge of the charge that you're pleading guilty to? Yes. And do you understand that you may have a limited right to appeal this guilty plea conviction? Yes. Do you also understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea? Yes.
Challenging anything about the constitutionality of the guilty plea, understand?
Yes, Your Honor.
Well, I want to make sure he.
Yes, ma'am.
All right.
Do you also understand, sir, that you have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion seeking to withdraw this guilty plea, which doesn't mean that the court necessarily would grant it or not. It's just that's the time areas of the law. Yes. Okay. Do you have any questions about that? No. Okay.
All right, and your attorney, Mr. Menendez, will represent you until 30 days from now or the last day of this term of court, whichever is later. And he would be the one to file any of those things on your behalf unless he is allowed to withdraw before that time. Understand?
Yes, ma'am. And just so the record's clear, I just provided to Ms. Percival the indictment, which was signed by all parties as it relates to the defendant's guilty plea to count one conspiracy to commit RICO. Your Honor, had this case proceeded to trial, the state would have shown beyond a reasonable doubt that between January 24th of 2013 and May 8th of 2022, this defendant, Mr. Farley, in conjunction with his fellow co-defendants, co-conspirators, known YSL associates, did unlawfully conspire to conduct and participate directly and indirectly in the enterprise YSL. In doing so, they did it through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise, that being YSL. Doing so,
I don't know why he's pleading guilty to that.
And territory of known YSL strongholder areas through acts of violence, also through other means such as social media, posting messages, images, and things of that nature. That's what the state would have shown as it relates to Mr. Farley and his involvement as it relates to the enterprise YSL and his association, Your Honor.
All right, I assume at least some of the evidence would have been the same as or similar to what was presented at the trial of some of the co-defendants that just was completed a couple of weeks ago.
Yes, Your Honor, very much.
All right, so I'll take that into consideration with regard to the factual basis as well. All right, anything else from the state?
Nothing further. Oh, the recommendation as it relates to, or the joint recommendation that the parties would make to the court. It's my understanding that the defendant obviously would like to tender his plea under North Carolina versus Alford, and I neglected to ask Mr. Farley, but it's also my understanding he qualifies for the first offender treatment, and he is asking that the court treat him as a first offender, which the state has no objection to either, and the recommendation will be 5 years to be served on probation.
All right, Mr. Farley, has your attorney discussed with you the First Offender Act and what all that means?
Yes, ma'am.
All right, and have you all discussed the potential upsides and downsides of that?
Yes, ma'am.
You understand that if you successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that, you would not be a convicted felon. Understand? All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, that not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty, and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alford. Do you understand that?
Yes, ma'am.
All right. Mr. Menendez, is there anything else that the defense would like to place on the record?
Yes, Judge, I just want to add a little bit of nuance to the plea in case the court's not as familiar, because a lot of it was on the front end. Mr. Farley is an HBCU graduate with no criminal record, and it's actually his marketing and his genius work as a businessman that even brought him into all of this, which is why we're asking the court to sentence us under Alford. In 2019, him and a friend created a clothing item, a hat that was like a satirical play on the Trump hat where it said "Make America Slime Again" instead of "Make America Great Again." And Your Honor, the clothing brand never said anything about YSL. It was just using this youth term slime, which I'm sure by now the court knows can have many different meanings in many different contexts. Mr. Farley is born and raised in the Cleveland Avenue area, and he does exemplify a lot of the great qualities of the people of that area: his creativity, intelligence, tenacity, his bravery.
I can't with the state. I cannot believe that.
When he was faced with this, government abuse. But what he did next, Your Honor, is he went to Myles College, and then despite having a vast network of opportunity from his bachelor's degree in business, he returned home because he is a family person. His dad is here in the yellow hoodie in the back. He's also an entrepreneur. That's where Myles gets a lot of that from. And so, Your Honor, when Mr. Farley made this clothing brand, he built off of the hat. In 2020, he made an LLC for Make America Slime Again, and he's actually employed by a record label to be a handler for a musical artist. And then he used those associations and that presence to promote his brand and to have his clothing be as visible as possible. He started making custom pieces for different artists and different people. And Your Honor, if you remember from the evidence that was presented, Mr. Farley's always wearing his own clothing, and he's only ever promoted his clothing for the purpose of himself and his business.
I cannot believe the state did this to them.
That's why, Your Honor, I think the most sincere and appropriate way to resolve this case is under Alford. The state, in that respect, did the right thing with its discretion, dropping the murder case. Mr. Farley had nothing to do with the death of Mr. Drinks. And so, Judge, he's been on house arrest. He's been totally compliant. He's not a gang member. He's never committed a crime in his entire life. But he is wearing an ankle monitor. He is confined to his home. It's better than jail, but I think we all know after COVID that that's not necessarily ideal. And he just doesn't want to go to trial. And that's why I think Alford is a textbook case for this type of situation. And so if the court has any questions, we just ask this honorable court to accept the plea as negotiated.
Okay, well, I mean, it would be determined by a jury at trial whether his involvement in the case is only because of his marketing and business acumen or something further than that, something criminal. But in tendering a guilty plea under Alford, Mr. Farley, you are admitting that while you do not believe you have committed the crime of conspiracy to violate the RICO Act, you are acknowledging that there is sufficient evidence that the state could present to a jury from which a jury could conclude that you are guilty of that crime. You understand that, right?
Yes.
All right. All right. I find there to be a factual basis for this plea. I will accept it under Alford, and I'll permit it under the First Offender Act. And I find the plea to be freely, knowingly, voluntarily, intelligently entered with an understanding of the consequences. And in accord with the negotiated recommendation, I am going to sentence you to 5 years probation. And as we discussed before, how you perform during the next 5 years of this probation is going to determine whether you finish that. A person who can say that they do not have any felony conviction, or whether you might be spending some time potentially incarcerated. So it's entirely up to you how you comport yourself and how you choose to behave going forward. What ultimately will happen at or before the end of that 5 years. Do you understand that?
Yes, ma'am.
All right. Are there any special conditions to this probation? Have y'all negotiated any?
I didn't have any special conditions obviously other than follow the law.
Okay. All right, well, that is the sentence of the court. I need to ask if you have a weapons carry license. Do you have a license? Okay.
No.
All right, that's fine. And while you cannot have any firearms during the course of your probation, if you successfully complete all your probation, you'd be able to possess firearms again. All right, Mr. Farley, good luck to you. I know that you have a very successful business, and let's just make sure that that business is on the up and up and that you are following the law. All right, good luck to you. Thank you.
Thank you, Your Honor.
And is there somebody here from probation?
If he would wait, Ms. Jolly is on the way.
All right. Mr. Menadas, wait until the probation officer, Ms. Jolly, can meet with y'all and get all of that taken care of.
Yes, Your Honor.
All right.
That one was
Yeah,
kind of
that'll be
messed up.
fine. And after you meet with her, then you're
We're just pause real quick, guys. Real quick, huge shout out to Patty LaBelle, who gifted 20 AV memberships. Thank you so much, Patty. If you're in the chat and just received a membership from Patty LaBelle, please say thank you. Very, very sweet of you, Patty, for stopping through and passing that along. But what did we just watch, guys? So we are in the third courtroom of the day, which is Judge Whitaker's. She has 5 defendants that are left on the YSL case to talk about either accepting plea deals, discussing bonds, things of the like. This first gentleman that we watched was Myles Farley, young man, right? The only thing that he did, they had a murder charge on him. The state decided to drop it. The only charge, and they did this to the young one, little Rod. The only charge was still RICO. And why is it RICO? What did he particularly do? He made clothing that said, "Make America Slime Again." That's it. He has a bachelor's, it sounds like a degree from an HBCU. Make America Slime Again. And yeah, you guys are criticizing the attorney. I'm gonna side with you on this one. He's pleading guilty to a charge. It's an Alfred plea, right? But you're pleading guilty for making clothes that said "Make America Slime Again." You have a record now. I mean, you could even hear it in Judge Whitaker's tone as she was reading this. She's like, "You're sure you want to do this?" Can y'all type "Make America Slime Again" in this chat? I mean, oh my gosh. But it looks like, he had house arrest, some other things. I'm going to get the specifics for you guys. A lot of these documents are going to be filed throughout the day, so we'll take a look at them. But that is one of the first defendants out of the 5 that we have lined up in Judge Whitaker's courtroom. 4 more. Let's keep going. And thank you again to Patty LaBelle.
Thank you. All right. Are there any other guilty pleas that are going to be tendered today? All right. So what I would like to do is, and we can just start up here with Mr. Minder, and I'd like the state to put on the record what the plea offer is. And I want everybody, all of the 4 defendants, and Mr. McMullen, we just heard from your attorney, and he believes he will be here by 11:30. He's apparently in Gwinnett County on some other case right now, and we'll have to just sort of wait until he gets here to handle yours, but this applies to you as well for everybody. This is the final plea date. It's your first final plea before me. I know that y'all had a final plea before Judge Dempsey previously, but I gave you all the opportunity post the verdict in the case with some of the co-defendants to negotiate if you chose to, and have a final plea date, if you will. But this will be your last opportunity to enter a negotiated plea in this case, meaning you all in the state have agreed to a recommendation, and you can be assured that if I do not accept that recommendation, that you can withdraw your plea. Now, you can obviously at any point in time enter a non-negotiated guilty plea, and that would mean that you decide to plead guilty, and the state will make a recommendation as to sentence. Your attorneys will make a recommendation as to sentence, and it will be entirely up to the court to sentence. Could be above or below what any of the recommendations are, could be exactly what one of the recommendations is, but as long as it is within what is permitted by the statutes. And then, of course, you have the right and opportunity to proceed to trial on the case as well. Does everybody understand that?
Yes, ma'am.
Okay. All right. So, Mr. Minder, you have this case pending, and you have another case pending as well. Is that right?
And Your Honor, so we were going to respectfully request to hold our announcement and to have an opportunity to approach the court at the bench at whenever convenient before we move forward with the final.
All right. So I will come back to y'all. So, Mr. Garlington and Mr. Mondelli and Mr. Abadi, can you put the offer on the record for Mr. Garlington?
Yes, Your Honor. Your Honor, on December 9th of 2024, the offer was relayed to counsel for Mr. Garlington as it relates to the possibility of tendering a guilty plea. The recommendation from the state was for the defendant to plead to count 1, conspiracy to commit RICO, count 49, which is the murder count, but it be reduced to the lesser included offense of voluntary manslaughter, and to plead to count 50, which is participation in criminal street gang activity, and then count 54, possession of a firearm during the commission of a felony, with a global sentence of 30 parolable time.
All right. And as a part of that plea offer, you all were going to null cross 40, 42, 43, and 51. Is that right?
That's correct, Judge.
All right. All right, and Mr. Mondelli, you discussed with your client the potential sentences that could be faced if he goes to trial and is convicted of all counts.
Yes, Judge, we've spoken extensively about potential risks of going to trial. I conveyed the offer to Mr. Darlington on December 10th, and we have had some discussions with Mr. Abadi since then. We are not in a position to accept the offer placed on the record. We will be rejecting that offer. I will state that.
Uh-oh, we have a rejection.
Yeah, and y'all can certainly present a joint recommendation. It's just not going to be negotiated per se at that point, in that you would have a right to withdraw the plea if the court didn't sentence in accord with that. But I mean, I will say, and this is certainly no guarantee, but I think across the however many years I've been on the bench now, I typically still, if there is a joint recommendation, certainly take that into account, and fairly often probably sentence in accord with that, but that is certainly not a guarantee.
Turn the volume
So,
up, guys.
Mr. Abadi, would you be able to put on the record?
And of course it freezes. Okay, what's going on with our feed today? Let me refresh it, y'all. Hang on. All right, it looks like they are on a break. We were somewhere right around here.
Sort of wait until he gets here to handle yours, yours, but this applies to you as well.
Recommendation from the state was.
Okay, here's where we were.
Plead to count 1, conspiracy to commit RICO, count 49, which is the murder count, but it'd be reduced to the lesser included offense of voluntary manslaughter, and to plead to count 50, which is participation in criminal street gang activity, and then count 54, possession of a firearm during the commission of a felony, with a global sentence of 30.
Oh, so it looks like that wasn't me, it was the feed.
All right, and as a part of that plea offer, you all were gonna null cross 40, 42, 43, and 51, is that right?
That's correct, Judge.
All right. All right, and Ms. Rondelli, you discussed with your client the potential sentences that could be faced if he goes to trial and is convicted of all counts.
Yes, Judge, we've spoken extensively about potential risks of going to trial. I conveyed the offer to Mr. Darlington on December 10th, and we have had some discussions with Mr. Gotti since then. We are not in a position to accept the offer that's placed on the record. We will be rejecting that offer. I will state that there are further discussions that are taking place. We understand, of course, that an issue though about any
Yeah, and y'all can certainly present a joint recommendation. It's just not going to be negotiated per se at that point, in that you would have a right to withdraw the plea if the court didn't sentence in accord with that. But I mean, I will say, and this is certainly no guarantee, but I think across the however many years I've been on the bench now, I typically still, if there is a joint recommendation, certainly take that into account and fairly often probably sentence in accord with that, but that is certainly not a guarantee. So, Mr. Abadi, would you be able to put on the record?
All right, Law and Crime, what is going on here?
You understand that? Or a not guilty verdict for most of the counts that faced the two defendants who proceeded all the way through to jury verdict. A trial for any of the four of you would be before a different jury. I would suspect that a lot of the evidence would be the same. The way it is presented might not be the same. The, I don't know, state's sort of story theory, if you will, might or might not be the same. And the ultimate outcome might or might not be the same. And I'll tell you, and I'm sure that all of your attorneys have told y'all, that acquittals with the jury are a rarity. So just keep that in mind. It does not mean that the same thing would happen to you. Y'all, you know, we've got a different prosecutor at the table who I hope would stay through the trial of the case. And it just is probably going to look a lot different. There's also a different judge at the beginning. So just keep that in mind. But I understand that for now, y'all will be rejecting that offer.
We have our first rejection taken to trial.
We've got Mr. Eppinger, and I know Mr. Eppinger still has a motion pending. I will tell, and Mr. Johnson, you should now have all of the transcripts from the main witnesses who testified around the two attempted murder counts at trial. And if we are not having a plea today, I'm obviously we're not going to have that hearing today, but I would be interested in going ahead and getting that scheduled. And I will say that I have heard the testimony as it was presented at the last trial, and I have seen the videos. I don't know what might be presented at the immunity motion, but I'm fairly certain that those two videos would be presented again, and I'm already familiar with that, as are y'all, having had it in discovery for a long time now. But we're going to go ahead with the final plea now. So even though that motion is still pending, any plea that you might be interested in tendering at some further point in the case, if you ever decide to do that, would be non-negotiated. Just,
Understood, Your
Mr. Eppinger, you understand that as well? Okay. All right. So, Mr. Body, can you put on the record what the offer
Next
tendered
is
to
Brist.
Mr. Eppinger was, please?
This is the guy that shot the cop.
The state's offer as it relates to Mr. Eppinger was a global sentence of life imprisonment as it relates to the armed robbery and everything else to run concurrent on this indictment. That sentence to run consecutive to the time he's currently serving in DOC custody, Your Honor.
All right.
Mr. Eppinger is facing a minimum of a life sentence and a maximum of 2 consecutive life sentences plus 145 years, Your Honor.
And I don't, this is just my quick count, but Mr. Eppinger is facing approximately 15 different felony charges on this indictment. Is that right?
Jeez.
That is correct, Your Honor.
All right. And if he were to proceed to trial and be convicted of all counts, in addition to everything running consecutively so that it would be, I'm sorry, I think you said 2 life sentences plus 100 and how many?
165 years.
165 years. That time could also be run consecutively to the time that Mr. Eppinger is already serving on whatever he's convicted of already. So have you explained that, Mr. Johnson, to Mr. Eppinger?
Yes, Your Honor.
You understand that, Mr. Eppinger? Okay. All right. And was there something else you wanted to say?
No, I just based on the circumstances, I came to the podium.
Okay.
But given the state's offer, Your Honor, at this time we would reject that offer based on our view and our view of the evidence in this.
Second
All right.
rejection.
So yes, we would reject that matter and like to proceed to trial.
All right. And once I get through everybody, or maybe everybody we can get through right now, I'll talk about trial dates. And I'll talk with y'all first about the immunity hearing date as well. All right. Thank you.
Your Honor, I believe that motion can be held as close to trial as possible.
Well, I mean, it could be, but I'm not interested in doing that. I'm interested in getting that taken care of as soon as possible.
Thank you, Your Honor.
All right. Not December, though. Not that soon.
Yeah, his charges are hard. He shot, I mean, it's body cam footage of him shooting that
Heard
cop.
everybody other than Mr. Minder at this point? Yes. All right. So let's talk about then the number of witnesses. I would think maybe about 4 or so for the immunity motion.
State would have no witnesses.
None? Okay.
Cop survived, guys.
Your Honor, as far as witnesses in the case, I believe the only witness that may be necessary is the
You can pick it up. It's not.
Is the complaining officer, Your Honor. That would probably be
Okay. Well, there are 2 officers who got shot.
Well, actually, there's only one who got shot. There's
Well, one who got shot at and one who got shot. You're right. I stand corrected on that.
So
your motion is just with regard to the one who got shot?
No, Your Honor.
I didn't think so.
No, it is related to both, but the other witness is not necessarily important for the
Okay.
motion.
All right. So that should be able to be taken care of in what, 4 hours at most?
I would imagine no more than an hour.
I mean, I think 2, but half a day at most, right?
I don't even think it'll take that long, Your Honor.
Okay. All right. So let's go ahead and get that scheduled then.
I guess I would have my inquiry with the court and counsel would be, it's the burden of the defendant to show that he's acting in self-defense. Typically, you don't call the complaining witness or the victim to establish your intent. harassing and self-defense, but I'm just.
I mean, if he wants, whomever he wants to call, he can call. And I get that, so do you think you'd be calling your client? Because it sounds like the state does not intend to call any witnesses.
Understood, Your Honor. It may be a situation where I may call my client.
Okay.
After discussion with him, and it may be a situation where we may the calling of the witnesses is just necessary for the introduction of the video, and we can make arguments based on that.
Okay. So let's look at sometime the week of January 13th.
Well, looks like that trial's starting soon.
The video, the state would stipulate to the video coming in, Your Honor, making a.
Okay. All right. Did you, I don't know if you heard that, Mr. Johnson. If it's just the video, then the state would stipulate to it coming in. I think there were. All right, let's do 10 a.m. January 13th.
We have a trial date for Christian Eppinger.
Your Honor, I did file a response.
Yes, I saw that. Thank you. I appreciate that. All right. And then with regard to the trial, we're at this point looking at potentially 4 defendants for this trial. Does the state have, I mean, the last time I asked, we still were facing 11 defendants. So do y'all have a revised estimate as to the time it would take to present the state's case?
I think it would be less than 90 days, but in an abundance of caution, instead of overpromising, I would say at the most 90 days.
All right. And when you say 90 days, you mean from the time we start presenting evidence till the time the state rests would be 3 months' time, not 90 days of trial time, right? Okay, just making sure. All right, and then obviously the defense would evaluate the state's case before determining whether they wish to present evidence. But any general idea what anybody thinks might get added on?
On behalf of Mr. Mender, if Mr. Mender was to go to trial, we would want 1 witness, and it would be who we would need in production.
Okay. Okay. Mr. Johnson, and I'm not holding you to it now, I'm just trying to get kind of an estimate.
Your Honor, based on our view of the evidence.
I need you to pick up that mic, I can't hear you.
Based on our view of the evidence, Your Honor, I do not believe that we'll have any witnesses for Mr. Evans.
Okay, and obviously that's assuming that it proceeds past the immunity motion. All right, and then I'll hear from Mr. Dark. But okay, so we're talking about probably still roughly 3 months. So 3 months is probably an overestimate on the state's case. Okay, so in terms of picking the jury, do y'all want to do jury questionnaires, or do you just want to have people in and do it all live? So, I mean, if this were a typical case, I wouldn't call more than 72, but.
My experience is that they are more comfortable being honest and letting their thoughts come out in the questionnaire.
Hey, excuse me.
So they're kind of talking about the logistics for the trial. And there's a few people that did not take plea deals. So Myles Farley seems like the only one that has taken a plea deal so far. The rest have been rejected.
All right, so I know that at least as sort of a pilot project, Jury Services here in Fulton has some, I don't know, tablet type things that jurors can answer the questionnaire electronically, but I think they basically like come in, but just sit and answer the questionnaire, and then we have them back another day for follow-up. So we could do something like that if everybody's amenable to that. Okay, and have y'all thought at all, I guess did y'all already go through at least part of jury selection in this?
We did.
Prior iteration? Some of you did and some of you didn't, right? All right, so, I mean, I would need to know what type questions y'all want. So can y'all by, let's say, January 20th, have the potential questions that you all want asked?
And I think the previous questionnaire was sufficient, but it was redundant.
Well, we don't want redundancy. I'm not a fan. Well, redundancy every once in a while is a good idea, but I want to be efficient. Okay, so I'll pull and look at the last questionnaire, and if, y'all do the same, and if there are ones that you think we can strike and any that you think we need to add, if y'all can just let me know that, and maybe we'll have, let's look and see what the 20th looks like. Maybe we can have, the 20th is the MLK holiday, so let's not do it that day. Let's do the 17th, which is the Friday before. Why don't we plan to just have like a status on, let's say 10 a.m. on the 17th of January? Where we can, so if y'all would submit whatever kind of additions, deletions you would like to the jury questionnaire by close of business on the 16th. We'll meet on the 17th for a status. And
The judge said, everyone in this courtroom on the 17th.
everyone who is still wanting to proceed to trial at that point in time. And in addition, Mr. Dark. And then I know the state had proposed, did y'all say February 24th as the beginning of trial?
Yes.
I had been thinking, I mean, is that a trial day for us? We can.
I'll speak in Mr. Dark's place. He had sent an email after I filed my motion. Apparently, he may have leave filed on that day. I can't.
Let's find out whether he does. Is it not filed in this case? Anybody else have any kind of, sorry.
Anybody else have any kind of an already filed conflict with beginning trial that day? Okay.
I have leave, but.
Is it already filed?
They are filed.
Okay,
But things can be rescheduled, so that's not an issue.
all right.
Does the court expect to have jury filling out questionnaires prior to the day that we're starting?
I mean,
Because there's a couple things that can happen.
yeah,
So one is the questionnaire, and with Mr. Bobby at the table, it might be more efficient, but the questionnaires give rise for strikes for cause out. So if we can agree to ones that are clear, then we can at least dwindle down and not have to waste time on whether or not.
people who are clearly going to be stricken for cause.
Right. And I think those things, like they can get the questionnaires done, we can.
Yeah, I mean, I definitely think we need to get the questionnaires back before we have them back for the, day of actual questioning, or days, I don't know, of actual questioning. So reading of the indictment is of us sitting there, or was a day. Multiple days.
Let's see what we can.
I mean, it may be that the state's not intending to go forward with however many overt acts it was before, 213 or
Oh, Jesus.
something. They may winnow down the indictment. Could you have that done before the 16th as well, or by close of business on the 16th? Okay. And I was going to say there's no reason to read the substantive counts that are against defendants other than these four or whomever it ends up being. But they may be overt acts anyway, but we wouldn't need to read the counts, even if they were included as overt acts. So, it would be a redacted indictment that we read. But yeah, we'll talk in more detail on the 16th. On the 17th about that, about, what date we're going to have jurors in, how many jurors we think we need to call, things like that. Okay. And then I know there are no, other than the immunity motion, no outstanding motions, but are there going to be motions in limine, evidentiary kind of things that have not already been resolved? I need y'all to think about that and get all of those filed by January 16th as well. Okay. Actually, if y'all could get those filed by the 15th, that would be good. And then I could be taking the 16th to start looking at them, and maybe we could talk through some of them on the 17th.
Can we have a deadline for a discovery drop-off link?
I would sincerely hope that all the discovery has been shared by now.
I know they're working on consolidating some of the new stuff that came out as it relates to during the trial.
Okay.
But that shouldn't take very long. I know Mr. Dark has received the majority of, it's just taken a minute, it's over 8 terabytes file for Mr. Dark. So that's been the focus. But I will make sure.
Yeah, so if you, the state, could put together your narrowed, cold, focused discovery.
It'll be, yes.
Can you get that? When do you think you could get that to all the defendants? Because even if they have everything, they'd probably rather have the smaller universe of things.
The first week of January, is that
Sure. Yeah, that works. All right, so that would be, find my calendar again. January 3rd. By close of business, January 3rd.
All right, so they're getting ready for trial. They're just talking through all the logistics.
All right, anything else we need to think about right now? All right, everybody else, I'm going to go ahead and release Mr. Abadi. Obviously, you'll need to stick around, and we had an anticipated 11:30 arrival time for Mr. Dark, so we'll hold on to Mr. McMullen as well, and then once we have Mr. Dark, we'll reconvene for his final plea and to discuss with him the deadlines we've set. Was there something else, Ms. Fagan? Oh, sure, yes, I'm sorry, you did mention that.
Okay, so it looks like they are approaching, and they have been gone for about an hour. Okay, so what is the status? What are we looking at? Let me give you guys a quick recap of the day so far. I'm just going to bring us up to the live feed. This is live. There's still one attorney that needs to come in and speak for Demise McMullen. His attorney was supposed to be there at 11:30. It is now 12:19 Eastern Standard Time, so he is severely late. Now, here's your recap of the day. So far, Gotti went to court and was represented by Kayla. And, he is not out right now. There was an outstanding warrant issue. The judge that was presiding over it did a scan, and that warrant issue came up. Usually, Gotti is defended by Doug Weinstein, who had a different matter to attend to in court. He does have other clients, guys. So it seems like Kayla was standing in for him today. I don't know if it's just official that Kayla's taken over moving forward. But for this matter, Ms. Bumpus stood in for him. Now, the judge needs to look at that outstanding warrant and the probation matter because there's, existing probation as well. The judge just wants to make sure he crosses his T's, dots his I's. So because of that, Gotti was not released from jail today. However, good news for Shannon Stillwell and Max Shard. Good news for them. They ended up getting Shannon some credit for time served, and he is going to be hopefully released today or is on his way to release. So it is a big win for them as well. What we're looking at right now is the third courtroom. We have 5 defendants that were scheduled to be in that courtroom. So far, 3 of them have rejected the state's plea deals and they want to proceed with a trial. Those defendants are Kristen Eppinger, Demikion Garlington, and Tencarius Mender. All right, so those 3 are deciding to proceed to trial. Judge Whitaker is kind of going through the preliminaries and to talk about what the jury selection looks like, different deadlines and dates that the state needs to be ready for certain things, what the evidence looks like. It's going to be a much more shorter trial. Projection on that one is looking like 90 days, so less than 3 months to present all things. Now, Myles McMullen is the last wild card of the day. We need to see if he's going to accept the plea deal that the state offers. If he decides to reject it, then we're going to continue on with trial for him. So I'm just checking in on the Law and Crime feed. We are all the way live. And again, this attorney is super late. So if anything, I will read us some super chats to kill time. And then I also have an immunity. There is some immunity from prosecution that Kristen Eppinger filed a motion on. So I have the state's response to it. So we can look at that as well. But let's go over here and check out our super chats. I did read a ton of them earlier, but let's catch up. Shout out to Miss L Boogie with the 10, says, good morning, AV. Good morning, Miss L Boogie. Really appreciate you. And thank you so much for being here, sis. Hollywood gifted 1 membership. Thank you so much, Hollywood, for doing that. Hope you're having a great day so far. Great Tuesday. It's going up on a Tuesday, y'all. Shout out to Kelly House, who has been a member for 4 months. Says, thank you for your hard work, AV. Happy holidays. Thank you so much, Kelly. Hope you're enjoying the holiday season as well. Shout out to Andrea with the 5. Andrea says, AV, will you be covering Brian Steele's new case defending the former DA who allegedly tried to obstruct justice in the Ahmaud Arbery case? Yes. Yes, there's a few things that are coming up. Obviously, it looks like we are going to get a date for the round 2 of this YSL trial, right? Which is going to look a little bit different. But these gentlemen have denied the court dates. Oh, sorry, their plea deals. So it looks like they are moving forward to a new YSL trial. So we'll see that likely in about February, March of 2025. Now, as far as this question, I was just talking to Dennis Byron about that on the phone today. I definitely think it is something that needs to be covered because, we talk a lot about corruption over here, right? When people cover things up, especially when a government actor does it. Now, a prosecutor is a government actor, right? It is interesting that Brian Steele is going to be representing her. And a lot of people have opinions about that because he's represented Young Thug. He's represented so many different people. Now, you guys know, and you've learned from watching this channel, there are cream of the crop attorneys in the state of Georgia. They're very expensive. Brian Steele being one of them. This prosecutor chose Brian Steele to represent her, right? And Steele accepted the case. Now, a lot of people have opinions on that because the Ahmaud Arbery case is messed up. What happened to him is not okay. So, it is kind of having, you know, some undertones of the wrongness that happened in that case, but also at the same time, Brian Steele's a criminal defense attorney. And if this prosecutor had done something to obstruct justice, that is a crime. And she's going to the best of the best to get representation. Now, what does that do for Brian's social credibility? I don't know. You know what I mean? What do you guys think? Does it change how you feel about Brian Steele, or does it not change? Let me know in the chat, because this is an interesting question, Andrea. But as soon as we get a trial date for that one, I absolutely want to cover it, right? Like shout out to Mars. It is his job. So I don't know what people are going to do, you know, as far as his social cred, his social credibility. We'll see. But look, a lot of people are saying, no, it's not going to change. No, it's his job. No, wow. So it's not going to change what you think about him. I mean, it is his job to get that money. I mean, some people are just like, I hope he loses, you know? I mean, it's a charged case. It's a very emotionally charged case. So I do want to watch it. And I want to see what the woman's excuse is for something like that. Like, how do you defend obstructing justice unless she believes she's not guilty? And in that case, here's why that case is going to be interesting. It's a former prosecutor against another prosecutor. So the state has to try that. So it is going to be, we're going to have to watch it from a different lens. Like, you know, with this case, we were pro-defense because we saw the mistakes that the state was making. But now we have to see the state get justice for Arbery. Are they going to be able to do that? Who's going to be at that table? What will we do if it's Miss Love? Interesting questions. It's a small prosecutor's office. Who is going to lead that? Is it going to be Hans? Is it going to be Abate? But as we know, Abate is going to be busy over here. Who are they going to put on that? Is it going to be Simone? Miss Hilton? Who knows? So interesting, but thank you so much for that super chat. And yeah, guys, we're just waiting for one attorney to arrive in the courtroom for Denise Demise McMullen's representation to see if he's going to accept a plea deal or decide to continue on to trial. And then we should be wrapping up for the day. Kelly House gifted 1 membership. Thank you so much, Kelly. Really appreciate you. And speaking of memberships, I do want to come over to our Cash Apps. I always forget about those. And they're super, honestly, they're a lot better to read and they're super convenient. So huge shout out to Chantel, sends me $1, says, can I please chat with you about the SB Kayla situation? Yeah, I mean, you're finding ways to reach out, you know? Thank you so much. Shout out to E. Capone, who sends me a $2 Cash App. He says, hola, when's the next meetup? Uh-oh, and it looks like we have some movement in the courtroom, or sound. So he might have, he's arrived. Let's see what's going on over here. All right, got a little bit of movement in the courtroom. What is going on with law and crime today?
For
Here we go.
Mr. McMullen, and I went ahead when I was addressing the rest of the remaining defendants and let Mr. McMullen.
Oh, come on.
Is the last opportunity.
Yeah, I'm sorry, he was trying to say something.
Yeah,
but I'm
no, go ahead. Go ahead.
Yeah, we're good.
Okay, this will be the final opportunity today to enter a negotiated guilty plea. And that would be a plea that both sides have agreed to a recommendation. And if the court accepts the plea that sentences to something outside of that recommendation, Mr. McMullen would have a right to withdraw his guilty plea. After today, any plea that is tendered would be non-negotiated, meaning that if he decided to enter a guilty plea, any sentence that was statutorily authorized would be a possible sentence, and there wouldn't be any right to withdraw the plea simply because of dissatisfaction with the sentence. I just wanted to make sure, and I know, Mr. Dark, you've told that to Mr. McMillan already, but wanted to make sure that's on the record. All right, and I'll ask Mr. Abadi to please let me know what the state's offer was.
Yes, Your Honor. On the 8th of December this year, the state sent an email to counsel for the defendant where the state agreed, or the state's offer was the defendant plea to count 1, conspiracy to commit RICO, and then count 2, but the lesser included offense of murder, voluntary manslaughter, with a sentence of 20 years to serve, all of that time being parolable or parole eligible. It's my understanding that at this time, the defendant is not accepting that plea offer. So he'd be facing a mandatory minimum if convicted after trial of life and a maximum of life without the possibility of parole plus 20 years, Your Honor.
All right, and do you understand that, Mr. McMullen? All right, and as I mentioned before, the fact that there was an acquittal of certain of your co-defendants does not mean that there would be an acquittal in a trial before a different jury with, you know, different prosecutors, different defendants, different defense attorneys. So it's a chance that you are taking, and you obviously have the right to proceed to trial. You also have the right to enter a non-negotiated guilty plea, although you could only enter a non-negotiated guilty plea to the charges that are in the indictment. I, as the judge, don't have any authority to reduce charges. So what I mean by that is, unless the state agreed to permit you to plead to voluntary manslaughter instead of murder, the only pleas I could accept would be to the murder and the conspiracy to violate RICO. So it's the prosecution's sort of venue, if you will, ability, and only theirs to lessen the charges. Okay, you understand that also? All right. Okay, Mr. Dark, is there anything you want to put on the record right now?
No, Your Honor.
Okay, and we discussed some timing already in your absence when I had the rest of the attorneys here. And what we all have settled on is the state gave an expected duration of trial of about 3 months. They think that's probably on the outside, but that's what we will anticipate at this point. We are going to have a status conference in this case on January 17th at 10 a.m. And we're going to discuss jury questionnaires and the voir dire process and things like that. And can you let me know, Mr. Dark, I know that some of you started the trial that already occurred, started voir dire, and some of you didn't, and I don't know what Mr. McMullen did. Was he a part of the past trial when it started?
Your Honor, Mr. McMullen told me that he's in custody for the past 2 years with no counsel, so I don't believe that he would participate.
Okay, all right. And when did you become involved in the case, Mr. Dark?
I just was appointed, I cannot remember right offhand, but I know it was within the last 60 days, I think, Your Honor, 60 days or more.
Your entry was August.
Yeah.
And that's a lot more than 60 days. That's more like 5 months.
August in the other case, and then in this case, it was in July 19th.
Okay.
Yeah, 'cause
5
he has
months.
some other case or something.
All right.
But Your Honor, as I was saying at the last court appearance,
Mhm.
I just got the discovery on this case on, I think, the 11th. And then I don't know whatever these other matters are.
And as I said to you at the last conference, you should have been able to get all of the discovery from the, oh, you said there was no prior attorney? Okay, well, it was your responsibility when you were appointed to the case in July to reach out to the state and say, I'm in the case now, I need the discovery. So I'm not going to delay the case past the trial that we're going to have of all of the remaining co-defendants. So you're just gonna have to spend your holidays getting up to speed.
Oh.
I'm not asking for a delay, I'm just putting on the record the conditions under which I'm working, and I want to be effective for my client.
And you were an hour late.
Just be forced into trial just because, for whatever reason, an attorney was finally found for him after 2 years.
Okay, well, there was no trial for him within the last 2 years. If you were appointed in July, you've already had 5 months and you'll have at least 2 more months to get ready. 7 months to get ready for a 2-count case is plenty of time. So use your time
Love her
wisely.
shade.
Mr. Abadi, did you already provide Mr. Dark with the discovery? I know we discussed that on December 3rd.
Yes, Your Honor, I believe it's everything, but I want to make sure I'm 100%.
Okay.
Yes.
All right. So the other dates. Lost my place now. Lost my place.
I think
Okay.
we've already seen who's going to be the problem in the next round.
So we are planning to at least start from the jury questionnaires that were used in this prior version of this trial, which should be filed. And any additions or deletions that you would like have to the court and opposing counsel by close of business on January 16th. And any and all motions in limine are due by close of business on January 15th. The state is going to take a critical look at the discovery and potentially narrow what is going to be used at the trial. So you should have everything now, but everything may become a smaller subset of what you have now. And so they will get that to all of the defense attorneys by February 3rd so that you know what you don't have to worry about in terms of discovery. And we are looking at February 24th to begin the trial.
Here we go, y'all. New trial date, February 24th.
And sometime between January 17th and February 24th, we may, before that date, get the jurors into, we're envisioning them coming in to answer the jury questionnaires on tablets. And so that we've got an electronic version of their answers and they're here. I mean, they may be here, they may be up in jury in the, I don't know if they'll be in the courtroom or not, but somewhere in the courthouse to answer the questionnaires, then get those to everybody and then have them back to do actual jury questioning and jury selection. So we'll talk about the ins and outs of all of that on our January 17th conference. All right. So do you have any questions for me, either of y'all, with regard to how the case is going to progress? All right. Okay. Then how about you, Mr. McMullen, do you have any questions for the court? All right. Are you going to want a few minutes to talk with your client after this, or did you have enough time beforehand?
I wanted to follow up because he had a question when we started.
All right. Okay. All right. We're going to go ahead and finish this, and then I'll give y'all some time to talk in the back. I want to talk with you before you go back there, though, Mr. Dark, about the appropriate way to handle attorney conflicts. All right. So this hearing is out of close. Thank you.
Guys, there we go. So we are going to have YSL Trial 2.0. That concludes all of our shenanigans for today. I mean, what did we see? Let's give you a brief recap for those, the cheap seats in the back. And I just jotted down those dates because it looks like we are going to have a busy Q1, busy start to 2025. So here's what's happening. Today, we started with Yak Gotti. He's not getting out today because of a warrant issue and existing probation. Kayla Bumpus did her best to stand in for Doug Weinstein and represent him today, but he is not able to come home. Shannon Stillwell was, he accepted a plea deal, got credit for time served, and is going to be able to come home. What they are trying to do with his probation, he does need to stay in Atlanta for right now. The judge is requiring him to get a GED. As part of the conditions for his probation, but they just need to make sure that the other state in which he is moving to is going to accept the probation transfer, and they are going to monitor and maintain his probation moving forward. So it's likely that Shannon's going to be released today, which is great news. Great news to Max Shard, friend of the channel. He was here last week, gave us a lot of intel, a lot of insight into the representation of Shannon, what it's been like so far. All of those things. I'm hearing that Kayla and Shannon's representation, Max Shard did a stream earlier. So that is something that's been happening there. The rest of these defendants, there were 5 of them that were scheduled for plea deals today. One of them accepted, and that was, he accepted a plea deal, which in my opinion was crazy because it's Myles Farley. And guess what he did? Guess what he did? Guess what he was charged with? They had a murder charge, they dropped it. It was the first charge, which was RICO. And how was Myles convicted of RICO? Do y'all remember? He made t-shirts and hats that said, "Make America Slime Again." That's it. DA's office came back, got their final lick in. He pled guilty to that. Okay, so that's what happened. And then the final 4 defendants said, "No, we're going to take it to trial. We're not accepting any plea deals from the state." That is when YSL 2.0 was born. So we are going to be looking at that particular trial. Now, you guys asked me about a couple other ones. Jackie Johnson is the disgraced prosecutor that Brian Steele is representing. I just looked it up and it looks like a trial date has been assigned for that one. That is January 21st. And of course, we're going to be covering it here. YSL 2.0, we just heard from Judge Whitaker, is going to start on February 24th. So we have 2 cases to start the year off with. In the meantime, for your holidays, I have several things that I am putting together for y'all. Lyrics is evidence. I have an editor working on that video right now. Editor 2 is working on the Shannon Stillwell, class action lawsuit. So that's the other thing. I don't think this is the last we're going to hear of Shannon and Kayla. They are suing Rice Street. They're suing the jail system. And it's not just them. It is a collection of people that have been impacted by the jail system. Class actions are basically a group of people suing one party, right? And a lot of times you'll see it against government entities. So with the Georgia prison system, that is a government entity. So you can expect to see more on that. Class actions do take quite a bit of time because there's a couple things that need to happen. The original complaint gets filed, and we saw that, right? So we saw Shannon drop that lawsuit. I think it was last week. And he's the leader of the class, meaning there's 2 main defendants. I forget the other gentleman's name, but it's a group of people that come together as members of a class, and then they sue somebody else. The class needs to be certified. So that's the next step. A judge needs to look at this and certify the class. And then once you get a complaint in the lawsuit, the defendant has to respond. So Rice Street, the Georgia prison system, has to respond to that complaint. So it's very early on in the process, but we know in 2025, maybe later 2026, we'll be able to see, how far that's going to go as far as making it to trial. But that would be a really big deal for a lot of people if there was a class action lawsuit. Because what happens? Let's say, because it's a civil complaint, let's say a judge or a jury finds that the Georgia prison system is at fault. Guess what they're going to have to do? They're going to have to pay the members of the class. And that's why class action lawsuits are interesting, because what happens is, let's say, the judge orders them to pay 20 million in damages, and there's 35 people in the class. You take that 30 million and you split it up between all the members in the class. Here's the thing. The bigger the class, the smaller the pot, the pot, but the portions of it are going to get smaller. So that's why class action lawsuits have their issues, right? But it's interesting stuff, So let's come back over to our super chats. And huge shout out to Kat Not Williams. She just sent me a text. I guess I can go ahead and announce it. Guys, it sounds like Moontunk has new lawyers. There's some buzz on Twitter. A lot of people have felt bad about what happened to Moontunk, but Moontunk does have new lawyers, and they are attempting to take a look at what happened with his probation violation and see if they can get him out, right? So stay tuned, keep your ear to the ground on that one. But that would be really good because, I think I had told you guys, I've seen some documents where there have been bar complaints on Moontunk's prior attorney and how he performed. So this isn't the first time we see that. I always tell you guys, check out the lawyers you hire. There are a lot of resources out there. A good one is avvo.com. It's avvo.com. You can look up any attorney and you could see, it's almost like the Google reviews of lawyers. Sometimes people will rate their lawyers, sometimes they won't. If you go to a lawyer's website, you could check out client reviews and testimonials and ratings there. But, you can do Google reviews, but avvo.com is really, and this is not sponsored, I'm just telling you guys where the resources are. Those are great ways to vet an attorney before you get started, right? So really, really cool stuff. And then, good luck to Moontunk. I hope that they can have something happen to help him out there. Okay, so we are going to come back to our super chats. And again, I caught up on the Cash Apps. Thank you guys so much when you send those. Those are very convenient. With YouTube, it takes a little while and they've got all these processing things and things like that. So, us creators always enjoy when y'all support us, right? Any way you want to support is fine. YouTube is a lot easier, but Cash App always really, really helps. So thank you guys so much. And I did catch up with our Cash App folks. Andrea, thank you again for the super chat. Kelly House gifted another membership. Thank you so much. And I think I left off on E. Capone right before we came back to court. E. Capone asked when the next meetup was. I'm not sure. I haven't talked to Lead in a while, but we used to plan yearly meetups. And, really a lot of that, we didn't have one in 2024 because it was really dependent on his health, but I'm sure he can give you guys some more information on that if he plans to do one. Shout out to the Happy Bird, who's been a member for 3 months. Thank you so much, Happy Bird. Appreciate your time with me. She says, happy holidays, AV and chat. Yes, yes, yes. Shout out to, and happy holidays to you too, Happy Bird. Shout out to Auntie, which I think these are €5. Auntie says, RIP Vices and content genius Michael Rivers. Horrible news today. Yeah, for those that haven't heard, LawTube has some pretty big losses in the last 24. Well, I'm not sure when Michael Rivers happened, but let me talk about Vices. Legal Vices, I put this on my community tab yesterday. If you haven't heard yet, he is an excellent attorney. LawTuber, has been around since Johnny Depp days. Right now we lost him due to a heart issue. It was announced yesterday. A lot of people are still kind of hurting about it, but I put a post up just honoring Jeff because he is one of the nicest attorneys that I've met on this platform. One of the only attorneys that believed in me personally. I'm just so grateful and happy to have met him. I've met so many other great people through him. Just even when he would vouch for me as a new creator, he's just like, no, AV's cool. Like, she's awesome. Like, she is a great creator. And he always invited me on to his panels, would leave me comments, super chats. He was probably one of the first LawTube people to ever send me a super chat. And I'll never forget that kindness. So we are having a memorial for him on December 27th. I will post it for those that are interested in attending, but great guy and will be remembered. I have had his song, I've been posting it everywhere. He had a little theme song. I think it was classic rock, but I've been jamming to that for the last 24 hours. So I'm definitely going to miss him and will honor him and continue to help out other creators the way that he helped me. And I think that's the best way to keep his memory alive. Second, Michael Rivers. You guys know Bruce Rivers, one of the largest content creators in the legal space. I think he's over 1 million now. But Bruce Rivers, he has that nice little Bruce Rivers. He's a criminal lawyer, right? Bruce Rivers has the Lambos, the cars going up. Bruce Rivers is paid, but his son, Michael Rivers, unfortunately passed away. I need to dig into that a little bit more. And I heard it was fairly recent. But, I think about our health all the time as creators. This is why sometimes y'all will see me just get up and go make a sandwich or go to the restroom or get some water and hydrate. also, you know, like as creators, it's important for us we're here to entertain you guys, but it's important for us to take care of ourselves too. So I'm still working on it, but I'm thinking about doing a workout challenge with y'all for 30 days or something, because your girl's trying to be here for a long time. Like, all right, like I'm not trying to, you know, get stressed out over YouTube. I don't think anybody should, you know, and I just think we just need to take care of our health, all of us. And if I could take you out on that journey too, I think that would be really fun. So thank you so much, Auntie. Shout out to Shanta, who's been a member for 3 months, as Max is there now, going between Yax and Shannon right now. Yeah, guys, we had 3 courtroom feeds up. I don't know why all of it wasn't just before Judge Whitaker. That's what I expected to happen, but they split it up last minute. So we had 3 judges, 3 different courtrooms today in earlier proceedings. Shout out to Darkside. Harley Girl with the 10 says Fulton is full ton of it. That's funny. Thank you so much, Darkside Harley Girl. Yeah, Fulton County, there's a lot going on. And as you guys can see, we've got a packed January and February. For now, we're going to go to Karen Reed starting this week. We're going to do a full Karen Reed 1.0 trial watch so I can get brought up to speed. Her second trial is set to happen in Massachusetts, and me and the content team are getting ready for that. We want to be boots on the ground in front of the courthouse, give you guys, bring you up to speed, let you know what happened in her case, what the conspiracies are, what the corruption is, interview a lot of people on the street, those sorts of things. And then we're going to kind of move from there and bring y'all up to speed. So it is a very, very busy season in the AV7 production line. Like we've been slammed, y'all, but we got even tonight, like we should have some videos ready for y'all tonight, tomorrow, Wednesday, Thursday. Like, there's a lot going on, but we're really excited about that one. Shout out to Mixed Chick Sammy, one of my faves. She has gifted 5 memberships. Thank you so much, Sammy, for doing that. Really means a lot. You know how much you mean to me and to the community. Thanks for all that you do and being here and helping out with the channel and everything. You're a doll. Love you so much. Thank you so much, Mixed Chick Sammy. Shanta's back with another 5. Shanta says, Shannon's YouTube channel, SB Chosen, has 783 subs. 1K, he starts a channel. That's right. I heard that he is starting to create his social media accounts. Likely Kayla is helping him out with that. That is very nice of her, because I'm sure he's got a story to tell. And if they are going to pursue this class action lawsuit, as you guys have learned from many of the attorneys that we've had on here recently, social media really does make an impact as far as public awareness, court of public opinion, what's happening with these cases, but it also educates you guys on what happens behind the scenes, behind the curtain, right? I think Ashley Merchant said it. When you could see how the sausage is made, it's a very different thing. It's a very different thing. So thank you so much, Shanta. Shout out to another one of my favorites, Michael Love. Always good seeing you over here, Michael. Drops a $5 cash app and says, basically, they held him in jail, and now they're exiling him from Atlanta and want some other jurisdiction to handle his probation. I mean, Michael Love, I couldn't say it better myself. Like, that's exactly what happened. You know, with Shannon's situation, if you guys caught it, and if you're watching this on replay, I will chop it up so you can see it in pieces. But one of the things that happened is one of the conditions is he is banished. They use the word banished from Atlanta, except for certain things. He can come back for funerals, weddings, major life events. It sounds like he has 4 kids. I'm not sure where the kids reside, but that's the other thing. You know, we saw this with Young Thug, this banishment from the city is something that was discussed during that time as well. But Michael Love, you're right. Like, he has to leave Atlanta, so he has to stay outside of the metro Atlanta area, or in this case, because his significant other is in another state, it's likely that he's going to go over there, and then somebody else has to handle his probation. And that's exactly what happened. Again, huge shout out to Patty LaBelle, Petty LaBelle gifted you guys 20 memberships. Thank you, Petty. Always a huge joy to see you over here on my side supporting the channel. That is fantastic. And I think somebody's saying Legal Vices is at 87,000. Again, you know, RIP to Vices. He means a lot to me. If y'all could do me a huge favor right now, if any of the mods are hanging around, drop the link to his channel in the chat. And although he is no longer with us, we're having a stream to celebrate his life. Give him a sub. You know, such a great guy. He really is. There's a lot of people out here, and you know, it's kind of hard to make friends with other creators. Like, I'm not even gonna lie to you, because you never know who is there to really support you and who is just a nice person. I'm telling you guys, you check out his content. If you're ever bored, he did the whole OJ trial, the whole thing all over again. He streamed it every day. It was so nice. If he's just a nice ball of energy, we're all collectively working together to get him to 100,000. So if y'all can do that, that would be fantastic. Thank you so much. You guys are saying that Max did an interview. I'll look for it in a second. Thank you to Kay Schmidt, who is a new member. Welcome, Kay. You're going to love it over here. Another one of my favorites, Full Drinking and Half Tinkin', $20 super chat. No comment, no question, pure love of the game. Thank you so much, Full Drinking Half Thinking. Y'all can also check them out. They're always supporting, and you might see me over there soon. Antoinette is in here. Member for 3 months, says, I'm so glad you're here, AV. I'm glad that you're here too. I'm glad that, I think we did 2,500 of y'all watching earlier. I'm glad that y'all still came back. A lot of people gave up on this YSL trial. Like after Thug pled out, we're done. Never wanted to talk about it again. But these are real people in this case, and we had started it, so we wanted to make sure that we finish it, right? So I'm really happy that you guys are still interested in seeing what happens to these folks. Shout out to Brandon Lesko. And that's right, we're trying to get Legal Vices up to 100,000. So if y'all could check him out, Mixed Chick just dropped a link in the chat. I'm going to put it in the description box because, again, his kindness to me is definitely something that I want to pay forward, and to other creators that are trying to grow as well. Part of the growth of my channel, like we just crossed 59K. Shout out to us, the little channel that could. We're growing. But I definitely want to be kind to others that are growing as well. And I think that would be beautiful as an accomplishment, because what happens when you hit 100,000 as a YouTuber? You get your play button. Jeff deserves that play button and more. So if y'all could check him out, that would be fantastic. And if you're interested, he's super funny. That OJ rewatch is amazing. Shout out to E. Capone, who sent me a $5 Cash App. He says, you're not going nowhere but the top, AV. Stay healthy. Yes, that's right, guys. I'm trying to get myself to 100,000. And that means that we're going to work for it. We're going to work really hard for it. We're going to have fun while we do it. And I'm going to live to my purpose, which is to educate you guys on the law. I have so much doing it. I could be like these people in the courtroom and go through the stress every single day. But I really enjoy helping you guys understand how this stuff works, showing you what happens day to day, having these fantastic interviews with these brilliant attorneys. And hey, there's other stuff we're keeping track of too. Last week, Ashley Merchant was here. And if you haven't checked out that interview, please do. We will link it at the end of this video. But Ashley Merchant was here. She was talking about the open records thing. And I also asked her, I said, hey, do we have a resolution to the Trump case in Georgia? Because guess what? He's going to be inaugurated on January 5th. So what is happening with that? She says we can expect an update on that case any day now. So that's also pending. We are going to be busy, but I'm going to put my head down, get these last videos done, get us on Karen Reed for the holidays. 30 days of Karen Reed is going to be a lot of fun. And then we will get all caught up on that one too. Thank you so much for you guys that are shouting out Vices. He's amazing. And I really appreciate you guys checking him out as well. All right, y'all, that does it for me. I have read all of our Cash Apps, Super Chats. I appreciate all the support, your time today, whether you hit the like button, you commented, let us know what you think about the proceedings below. We've got a ton more content happening for you guys, but I want to leave this stream with one thing, and we are talking about it a lot. But if you guys could do me a huge favor, I'm trying not to cry right now. Jeff is an amazing person. If we can end this stream by saying RIP Legal Vices, that would mean a lot to me and a lot of other people. Kindness never goes unnoticed. And he was just a great person. He left too soon. And I will always be grateful to him and the growth of his channel. So if y'all can type in Legal Vices, that would be huge. And I was trying to hold that in, but thank you so much for all the well wishes on it and all the people that really cared about him. LawTube is a small community, and nobody ever wants to like ball on screen. But I'm just really sad because he was just an amazing guy. And I'm always going to be grateful for that kindness. So if you're a growing creator out there, I will do what I can in memory of Jeff to help you. But thank you guys so much for watching. Stay safe out there. I'll see you in the next one. Bye.